Okay. On the record, in the matter of J.P. Morgan Chase versus Michael Crosby, file number is 22-01306 GC. Council appearance.
Good morning, Your Honor. Preston P77884 appearing for J.P. Morgan Chase.
Okay, did Mr. Crosby appear?
I didn't see him this morning, and I don't think he's here today. However, he's probably not necessarily needed. Today's are actually a motion to amend the consent judgment that was entered earlier. When the consent judgment was entered, it looks like we added the cost onto the judgment. JP Morgan requested us not to do that. So unfortunately, I don't know why it got entered like that originally, but we are asking the court to amend the judgment just to remove the court costs and the filing fees, things like that. We're not going to be requesting those from the defendant, just the original balance.
Okay, I do see a motion to amend the consent judgment. I will grant the motion. And the cost be removed. I think you did provide an order, so I'll sign that as stated for today.
Very good, Your Honor. I appreciate that. Thank you so much.
You're all set. On the record, in the matter of Ford Motor Company versus Nelson Mandela and Namahana Emanuele, file number 22-02030 GC. Council appearance.
Good morning, Your Honor. Deborah Winslow on behalf of Ford Motor Credit Company.
Okay, and I see Emanuele, and who is that with you, sir? Is that Nelson Mandela?
Yep.
Very good. Today's the date and time that was set for a motion to set aside default judgment. I have a note here that the parties did reach a resolution. Is that correct?
We have, Your Honor. If you recall, we appeared for the pretrial. We attempted to resolve it with the signed order, but I believe due to Mr. Emanuele being out of the country, and then they had some email issues. So we didn't get the signed order back originally. So we filed our motion for summary disposition. We again kind of reached that same agreement. And they again had email issues in getting that back to us. So when they did not appear on the 18th, Your Honor entered judgment. And then we have since spoken again and have resolved this matter for the original agreement with some corrections. And if I could put those terms on the record and just follow up with an order under the 7-day rule, if that would be okay. Okay, Your Honor, we have agreed to set aside the default judgment, to enter a dismissal without prejudice pursuant to a payment plan. The defendants have agreed to pay the sum of $9,503.81 at the rate of $200 per month, beginning July 25th, 2023, and due on the 25th of each month thereafter. Should they default on that agreement, we would submit an affidavit of default with the court and ask the court to enter a default judgment at that time for the balance originally paid for in our complaint, plus court costs and statutory attorney fees, less any payments made up to that point by the defendants.
Okay, Mr. Mandela, is that accurate?
Yeah.
Mr. Emanuele, is that accurate?
Yes.
Okay, so those terms are noted here on the record, and so the court will note that the default is set aside by stipulation. It sounds like there's a conditional dismissal that will be forthcoming. Are you going to grant Ms. Winslow permission to sign that agreement on your behalf?
Yes.
Did they both say
I
yes, Your Honor?
I need a yes from both of you.
Yes.
Okay, do you have any questions today?
No.
Laura.
Okay, sounds good. Any additional matters for the record today, council?
No, Your Honor, so I will just sign with permission on, how did I say that? Just with verbal consent? Or-
Yes, with, you just put with consent, and that was on the record.
Okay, perfect. And then I'll submit that to the court. Does it need to be under the 7-day rule still, or?
It does not, because it's just gonna be a
Perfect.
conditional dismissal with
Thank
those
you.
terms stated. Okay, sounds good. Any additional matters for the record?
No, Your Honor.
Okay, you're all set. Thank you.
Thank you, Your Honor.
No problem. Are they on their device or our device? Yeah. Okay. We're on the record in the matter of Farm Bureau Insurance versus Shonda Javon Mitchell, an unknown insurance company, file number 22-02830 GC. Appearances for the record.
Yes, good morning, Judge Simmons. Mark Heipner appearing on behalf of the Plaintiff Farm Bureau.
Is Shonda Mitchell present?
She shows up on my screen, Your Honor, but she's muted.
Shonda here. I didn't know how to
Okay.
work this. I'm sorry.
Okay, all right. Can you adjust your screen so I can see you? Okay, thank you. Today was the date and the time that was set for a pretrial. Any motion? What's the motion?
Your Honor, today is the date set for a pretrial, and it's also the date and time set for a motion that I filed last time we were before you. You indicated we could have it heard at the same time for convenience of the parties.
That's it. It's not set for a motion. It's only set for a pretrial. You paid for a motion,
I did.
and when was it filed?
On May 30th.
Okay, we see a motion fee was paid on June 2nd. Let's see, where's the actual motion? We have the motion, is that, who's getting motions and just putting them in files? Civil?
Yeah, and they didn't set it for a motion either.
Okay, and was that motion served on Ms. Mitchell? Ms. Mitchell, did you
Yes.
get a copy of the motion?
I don't know what any of this stuff means. I got paperwork in the mail.
Okay, did you receive a motion to strike?
I'm sorry. I don't, I'm court illiterate. And I couldn't afford an
Okay.
attorney.
Okay, what paperwork did you receive?
Just the paperwork that said to show up on the Zoom meeting today, and that, something regarding why he didn't show up to court last time.
Okay, well, I'm asking, did you receive anything else? It should be on the form state motion to strike.
I can grab the paper, but I'm not sure.
Judge, I'll indicate for the record, I did send it to her at the address that's on the pleading, and I filed a proof of service with the court.
Thank you.
It just says civil pretrial instructions.
Okay, so you filed a motion, sir, to strike her pleadings, that being her answer, correct?
Yes, Your Honor, it's actually quite simple. The answer that she filed is essentially one paragraph. The complaint has 28 separately numbered paragraphs. I simply ask that she comply with the court rules and the dictates of the form that she used, which says that you have to answer each of the paragraphs separately and put the numbers next to them so that I know what her defenses are to this case and to the specific allegations that are made.
I don't even know what allegations are being made besides a tree was hit.
Okay, I'm gonna deny your motion. She is improper. It's common that we get a one paragraph answer like this because she can't even tell me if she received a motion to strike. It's germane to make her have to, it's not germane to make her have to go through each paragraph and put she denies, and she denies. Her paragraph very clearly states that she's disputing it. So I'm gonna construe that as her disputing the entire lawsuit, and you can discuss whether or not she has any defenses as part of this pretrial, because that's going to be part of the joint pretrial statement. I don't know that she has any defenses or not. I think it's stated as indicated in the writing, she disputes it. And so, ma'am, I don't know if you're intended to hire an attorney, but you're moving forward in a lawsuit without one. Do you recognize that?
I can't afford an attorney. I can't afford an attorney. I'm on a fixed income. I'm disabled, and I have 3 foster kids, so I can't afford an attorney. And I don't know any of this language, so it's kind of frustrating because I don't know, the court language.
Okay, I recognize those things. So what we'll do is, can I have a pretrial form, please? We'll go through the joint pretrial form to make sure that takes place today. The joint pretrial form will be what we use to kick out your scheduling order. Yes, thank you. Okay, and so did he receive a copy of our standard? He's just using the scale form anyways, but pretrial form for him to complete with her? I don't know if he received it. Okay, I'm gonna put the parties in a private meeting room so that you can complete a joint pretrial statement. You'll address whether or not you have any, or what the issues are. What the motion to strike this pleading is gonna be denied because she's not gonna be able to complete an answer in the form that you're requesting, as she's improper and she's not in a position to understand, I think, even the basic requirements of this lawsuit. So it's not meaningful. She's denying the allegation. Doesn't sound like there's gonna be much discovery required, although it does state in her answer, she's requesting some pictures or some sort. I'll discuss with her on the record later how she'll go about doing that. You'll discuss damages, any joinder of claims, any admissions of fact will be discussed, and how much time you believe you need for a trial. I don't believe we received a jury demand.
Yes, you did.
Let's see here. You said she filed a jury demand?
I did.
Oh, okay. You filed a jury demand. Okay, so this, we'll need to know how long it required, or you believe it's gonna be required for a jury
All right.
trial. You paid the fee for the jury trial that's in there.
Judge, to move this along, I'm happy if the court sets the deadlines for discovery, witness lists, exhibit lists, and trial. That's fine, doesn't matter to me.
No, we don't set it. You do it in a joint pretrial statement. That's our standard procedure.
Right, and I'm gonna talk to the defendant who doesn't understand any of the procedures. That's the problem.
Okay, well, to the extent that you go through the list and you put what you are looking for, the court will address that on the record, but I'm not going to prepare your pretrial statement for you. So I'll put you both in a private meeting room. If it becomes too taxing, I can have you all appear in person and we'll do it together. Off the record on that matter. Request to adjourn. Let's see. On the record in the matter of Triad Financial Services versus Karen Allen, file number 23-01005 GZ, council appearance.
Good morning, Your Honor. Attorney Elizabeth Ellison, P 82098 for the plaintiff.
I see Karen Allen is present via Zoom. Ms. Allen, do you have an attorney?
Yes, I'm here.
Do you have an attorney, ma'am?
No, I don't.
I'm sorry?
No, I do not.
Okay, today was the date and time set for a pretrial. My understanding is that there's a request to adjourn.
That is correct, Your Honor. The defendant is going through the My Half program. They actually sent out a check. It just got lost in the mail. So my client is working with the program provider to find out what's going on with that check to see if it can be reissued. And then once it's applied, we'll know her actual true balance. And I think the program might continue to work with her if there is a balance. So we think we're going to be able to get this resolved, Your Honor. So we're just asking for maybe a 30 to 45 day adjournment.
We can do August 8th too.
August 8th at 2 p.m.
Thank you, Your Honor.
Do you have any questions today, Ms. Allen?
No, other than I was wondering why I hadn't heard anything, because I had been waiting to send in a payment, and I was told not to send anything in until we found out what the final balance was. But now that Ms. Ellison explained that the check was lost. That makes a lot of sense, why I hadn't heard anything. So I'm satisfied with that response.
Okay, I'm gonna be quite honest, I barely understand what you're saying.
I'm sorry.
I barely understand what you're saying. You have a very bad connection. I don't know what kind of device you're on, but it's very muffled on my end.
Okay, yeah, I'm using a tablet. There's something that isn't it for Zoom. So you want me to explain that again?
You know what you're saying? Okay, we don't know what you're saying, ma'am. You're gonna need to appear in court in person for your next court date, okay?
Okay,
Okay, so at this point, the matter is gonna be reset until August 8th. If you all resolve it, then we won't, I'll look to hear from you, Ms. Ellison, as to whether or not you still need this next court date. Otherwise, I'll expect to have the pretrial held on August 8th at 2 p.m. in person at the court.
Thank you, Your Honor.
Thank you. Any additional matters for the record?
No, Your Honor.
Okay, you're all set.
Thank you, Your Honor.
Your Honor.
Yes.
That room, there's nobody there.
Okay, Mr. Hepnar is back in the main courtroom. I don't know if he can hear us. Alan, you're free to go. Okay. I'm going to reset your matter for in person. June 28th. June 28th at 8:30.
Am I allowed to bring my kids to this? Oh, God.
I'm not gonna- you need to be able to conduct a court proceeding. So if it's going to be distracting to you, you need to make arrangements, ma'am. But you're welcome to bring your children so long as they're not going to distract you from being able to deal with what you have to deal with.
Okay.
You have any other questions today?
No. That's
Okay,
it.
we'll see you next week.
Thank you.
No problem.
7.
Which matter is Jane Miller? Okay. On the record in the matter of Velocity Investments versus Joan Miller, file number 22-02659 GC, council appearance.
Good morning, Your Honor. Brad Johnson, P75416, on behalf of the plaintiff.
And I see Ms. Miller is present via Zoom. Ms. Miller, can you hear me?
Yes, ma'am.
You have an attorney?
I do not.
Okay, the plaintiff has filed a motion for summary disposition. Did you respond? Because I don't have your response.
No, I didn't end up having time to do that, but we discussed in the breakout room.
What did you
Sure, we
just?
have a proposed settlement to place on the record, Your Honor.
Okay, you can proceed at this time.
Thank you, Your Honor. Me and Ms. Miller agreed to a consent judgment in the amount of $5,27.88, which comprises agreed upon damages in the amount of $4,800, costs in the amount of $152.88, plus a statutory attorney fee of $75. A condition to this judgment entering is that plaintiffs shall not institute any involuntary collection efforts until after January 15th, 2024. Ms. Miller is 8 months pregnant and just needs time to budget that, obviously, into her budget before she can address this judgment, which I totally understand. But other than that, she's been wide-eared on her right to have a hearing today as well.
Was $5,202 or
$5,027.88, and I do have a proposed judgment.
okay, so that's a different amount than what was in the judgment attached to the file. If you can bring me down on that one. Okay, so. Okay, Ms. Miller, is what the counsel for the plaintiff stated on the record accurate as to your understanding how you're going to proceed?
Yes, ma'am.
Okay, so you want to enter into consent judgment and you're agreeing to judgment in the amount of $4,800 plus $152.88 in cost and $75 statutory attorney fee for a total of $5,027.88. Is that correct?
Yes.
And you understand that you had the right to have a hearing today?
I do.
You have the right in this matter to proceed to a trial?
I understand.
Okay, you're willing to waive your right to a trial?
Yes, ma'am.
You also have the right to be represented by counsel. You would have to hire an attorney, but you have the right to have that representation during these proceedings. Are you waiving your right to counsel in order to enter into consent judgment?
Yes, I don't think I can afford one, and I assume that it would cost more than the amount of this judgment.
It's a valid assumption, but you still have that right. And so if you want to waive it, that's up to you.
I am
And
waiving
so, okay, thank you. Anybody making any threats to you or promises to get you to waive your rights today and enter into this consent judgment?
No, ma'am.
You have 3 business days from today. If when you leave here, you realize you misunderstood the rights that you waived, you can return to the court. You can request to have this judgment set aside, and then we'll set this for a hearing, okay?
Understood.
And do we have your permission to put your name on or your signature on this document for the consent judgment?
Yes.
Any questions at this time, ma'am?
None. Thank you.
No problem. Any additional matters for the record, counsel?
No, Your Honor, thank you.
Thank you. You're all set.
Thank you.
Thank you, Ms. Miller.
Thank you.
No problem. We're on the record in the matter of Ilya Maya versus Dependable Auto Sales, file number 22-02329 GC. Attorney here? Or the attorney? Okay. I don't know if it's client here. Can we get the attorney, please? Ilya Maya versus Dependable Auto.
I'm sorry, Your Honor. We were just,
Okay, appearance for the record.
Frank McAlpine with Mr. Camille.
Okay, and you are representing yourself, sir? State your name for the record. Okay, today's the date set for a bench trial. Are we ready to proceed?
Yes, Your Honor.
Okay, it's your show. Let's go. You can call your first witness.
I don't have any witness.
Okay.
I can't lie about it.
You have any evidence?
Evidence about the fire.
Evidence of your lawsuit. You have to bring evidence to prove your case. What evidence do you have?
I have my title, my car title.
Okay, your car title. What else do you have? Okay, are you gonna testify?
I mean, yes, ma'am, I would, but
Okay, how do you expect to prove your case if you don't bring any evidence or testimony? What do you mean you could? You're gonna have to give me something.
I had pictures in my other phone, but I just lost it.
Okay, you had pictures in your phone, but you lost what? Your phone?
Yes, ma'am.
Okay, so you don't have any evidence, sir?
No, ma'am, that's the title.
The title just shows me ownership. It doesn't show me any proof of a lawsuit. How do you intend to prove your lawsuit?
That's all I got.
So you don't have any evidence to prove your
No,
lawsuit?
ma'am.
Okay. Are you making a motion to dismiss without prejudice?
Yeah, I mean, like for now, things are going so bad for me because of that thing, I have lost 3 jobs down here. And my kids, my 2 daughters are sick in Atlanta. I even drove like today, like I slept driving just to do this for today. So for me, I was just saying, and dismiss the case.
Okay, and I said dismissal without prejudice because we have not had a trial, and then that gives you the right to file your lawsuit if you do come up with the evidence. But right now, you don't have anything to proceed. We're just standing here, and all you have is a title. You have to bring evidence. It's your responsibility to prove it.
Yes, ma'am.
What happened?
I had all the pictures in the phone. But that was my phone.
Okay, counsel.
Your Honor, I move that the matter be dismissed with prejudice. At this point, there's date one, and we don't want to go through this again. There was no evidence to begin with in this case, and we just want to dismiss with prejudice.
Okay, well, I have not received any evidence to even consider, so I'm not going to grant the dismissal with prejudice, but I know you have to ask. And so the dismissal without prejudice is going to be granted. Again, that means that without prejudice means you can, if you get the evidence, reissue or refile your lawsuit against them, okay?
Yes, ma'am.
Okay. Do you have any questions?
No, ma'am.
Okay, any additional matters for the record, counsel?
No.
Okay, okay. A dismissal of sign. Can you put me in dismissal, please? Okay. Sitting back there, we'll get the next people going.
Oh, ma'am, thank you.
Thank you. We're on the record in the matter of Hunter Townhome Properties versus Jasneek Milton. File number 22-043004 LT. Council appearance.
Good morning, Your Honor. For the record, Daniel Landman, P35797, appearing on behalf of the plaintiff.
And ma'am, what's your name?
Jasneek Milton. I'm representing myself.
Thank you. Today's the date and the time that's set for a bench trial. An eviction matter. Are we ready to proceed?
Plaintiff is ready, Your Honor.
Ma'am, are you ready to proceed?
Yes, Your Honor.
Okay. You can proceed, Mr. Lang.
Thank you, Your Honor. Your Honor, this is a summary proceedings action based on a rent arrearage. The 7-day notice in this matter actually was filed back in October. The case was filed in December, and it's wound its way through the system, and we're here now. Your Honor, we believe that the evidence is going to show that there is currently an outstanding balance of $17,005.03, not including costs, on a lease that is due to expire at the end of next month, the end of July 31st. Your Honor, based.
Ma'am, you can be seated.
Sorry.
The evidence is also going to show that no payments have been made rent-wise to our client since August of 2022. So this tenant has not paid in approximately 10 months as we sit here today. Your Honor, the landlord-tenant statutes are pretty clear that if a tenant is withholding rent, it's supposed to be escrowed. The evidence is going to show my client has not received notification of any type of escrow account. There is no evidence that any money has been deposited into escrow by this tenant. She has essentially been living for free.
Let me stop you really quickly. Could somebody print out the civil dismissal? Send these people on their way. Thank you. Okay, you can proceed.
Thank you, Your Honor. Your Honor, the tenant claims that she has been locked out of the leased premises. The evidence will show that my client has never changed the locks or prevented the tenant from accessing the premises. The tenant claims that she has been unable to live at the premises since November due to an issue with her furnace. The response to that, Your Honor, is firstly, she didn't pay rent in September or October, even though there was allegedly not a defective furnace. Secondly, the furnace was addressed, and we have maintenance people here who will testify to that fact. Thirdly, there was not a single, and the evidence is going to be presented, there was not a single work order that was submitted to my client between the months of roughly October, November, and April, and nothing since April. And finally, Your Honor, if the tenant really has had to live elsewhere, she certainly could have cut her losses and turned in her keys. Instead, if the property has been sitting vacant, the rent has been accruing the entire time, so the tenant has not mitigated her damages. The evidence we believe is going to show, because we're going to present the work orders, that any work order that was submitted properly by the tenant was addressed. So my client has made reasonable efforts, which is all that the law requires, to keep the premises in reasonable repair. And in fact, my client believes that they have kept the premises in reasonable repair during the lease term based on those work orders that were known to them. The evidence is also going to show that there were work orders that were presented by the tenant, and that when maintenance people came out to address them, they were told to leave. So it's very difficult to take care of a work order when you're not given access to the premises. Your Honor, we are requesting today that the judgment enter as prayed for. The tenant believes that she's entitled to a set-off. Certainly, it is not going to be a set-off for 10 months of free rent. And so if the court chooses to make an adjustment, that's certainly your prerogative. But when all is said and done, we are asking that a possession judgment enter. And again, I would note, this tenant's lease expires of its own accord at the end of July. So irrespective of the ultimate outcome today, and we do believe that the possession judgment should enter, this tenant will be vacating as of the end of July, or we'll be back before you on a termination action based upon the expiration of the lease term.
Milton, did you want to make a opening statement?
Yes. Upon moving in, I signed my lease back in June. I asked for an update because they switched the unit. and I asked for an updated lease. I was not granted that. So to this day, the lease that I have is not for the unit that the key was given for. I made contact within the first week to the plaintiff in regards, by phone call, in regards to all the issues that I was having. On August 30, no, actually on September 9th, someone from Hunter Management signed the notarized letter that I sent in regards to all of the issues that I was having. Back in September, there was a new property manager that had just been on site for a couple of days. I reached out to her to let her know via phone and email of all the issues. Upon moving in, I did not receive anything to show how maintenance requests were to be made. It wasn't until months later that I found out that all maintenance requests were to be made online. I, however, did not receive a website or anything. August 31st, included in that letter, I advised them that their rent would be put in escrow for September. And I also notified them that for the things not finished, that the October rent will be in escrow. I do have proof of September and October's rent in escrow. As far as for November and the remaining months, maintenance requests had not been made. Therefore, and I was not able to live in the unit, and without a valid rental certificate, I'm unsure of who I am to be paying rent to because I do not have a unit that I live in. As far as being able to enter into the property, in the beginning, they were leaving note tags, door tags, I will say. I have all of the door tags that they left. I have there was only one that specified that there was no person here at the home for them to enter. So therefore they did not enter. However, in recent months, they have been in and out of the unit because of the mold and the flood. And I have not received any maintenance tags letting me know that they're in or out. I'm just finding out by going in and out of the unit, checking on them. As far as for, let me back up. There were issues that were made. There were issues that were, when I moved into the townhouse was not ready. There was still maintenance equipment in there. The office hours did not comply with my work hours. I was working for Spare Hospital at the time. So their open hours and my work hours collided. So there was no way outside of a phone call from the mate. I do ask that the court throws out this case due to the first filing was filed in the wrong jurisdiction. And I have proof that I asked the first time via email in June when they moved my unit. I asked that they updated the lease and give me a new lease so that I can have it for my file, and that was not done. So as of this date, I do not have a valid rental certificate for that property.
You said you want it thrown out for the wrong jurisdiction?
One of the reasons for it being originally filed. And the original file was in East Lansing. That's the first court that we went to. And then when I went there, we had a hearing. The second hearing was dismissed without prejudice. I was not notified until I went down there, and then I got a court record. And then a month or two later, I received a notice of summons.
Okay, so they probably did file in the wrong place, but it's in the right place now. So
Okay.
I can't dismiss it because they previously refiled it in the wrong place.
Okay.
The other court dismissed it for that reason.
Okay.
Okay, but we can address, and this was just your opening statement, so that means you're just telling me what you're going to, what you intend to prove today with your evidence, okay?
Okay, I intend to prove that the unit was not in habitable living space. I have 4 small kids that were living there with me. They are not living there. We are not living there now. And I tend to prove that the rental certificate is invalid. Therefore, no money is up to be owed. And then I can prove that rent was put into escrow for September and October, and those are the months that I notified them.
Okay, thank you. Mr. Lambert, you can call your first witness.
We'll call Ms. Milton, Your Honor, as an adverse witness.
You are calling her as an adverse witness.
Yes, Your Honor.
Okay,
You're the adverse party, so he wants to call you as the witness.
okay.
However, you can object to that if you'd like.
Object.
Okay.
Your Honor, we have the absolute right under the adverse witness rule to call Ms. Milton. And to the testimony, she's certainly later entitled to present her case.
Correct. But I have to give her the right to object. Did you know why you're objecting?
Because I've made contact with them and I'm objecting because I was not notified that I was a witness. I was not notified in any writing that I would be a witness in this case.
Well, you're a party, so.
Okay.
And you're intending to testify later, correct?
Correct.
Okay. Let me swear you and raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
I do.
You can have a seat. I'll let you testify from there.
Okay.
Thank you, Your Honor. Ms. Milton, you reside or assigned a lease to reside at Huntertown Square Properties. Is that correct?
I did sign a lease. That is
And you
correct.
signed it on June 6th of 2022.
The lease that I signed on June 6th of 2022 was for 4730 Duvernay Drive, Lansing, Michigan, 48910.
And under the terms of that lease, your rent was how much per month?
Under that, the total amount would amount, including renter's insurance, internet, and the rent of the amount would have been $1520.
All right. And the lease was supposed to start August 1st, correct?
Correct.
And end July 31st of 2023, also correct?
The invalid lease was too correct.
All right. And it's your position that because the lease was for a different address, you get to live at 4732 as long as you want?
That is incorrect.
All right. When do you believe your lease or the term of your tenancy expires?
The term of the tenancy, as far as now, there is no valid rental certification. The lease that I requested and that I signed, I was not assigned to that rental unit.
I'm not sure that's responsive to the question. Do you believe because you don't have a lease for 4732 that you're there for a month-to-month tenant?
I answered that question. No, I do not believe that.
All right. So what gives you the right, if you don't have a lease for 4732, what gives you the right to reside there?
Because Hunter Townhomes went into a lease agreement and I asked for them to update the lease agreement, and therefore Hunter Town failed to update that lease agreement. Therefore, I requested that issues be made and they were not. So therefore, I have not been able to reside in that home.
Is there anything in the townhome right now?
There is furniture in the townhome.
All right. And I guess I'm missing something. You claim you don't have a lease. You claim that, but you still claim you get to occupy 4732 indefinitely without paying rent. And I guess I'm asking, and I understand you're not an attorney, but I'm asking, what is your theory as to why you get to live for free? And at a property address that you have not signed any kind of agreement to occupy.
Can you define the definition of live?
I need you to repeat your question.
Yeah. My question is, I asked her basically what her theory is as to why she gets, if she says there's no lease for the premises, why does she get to occupy it? Why does she get to have furniture there and not pay any rent? If she has no legal leasehold in the premises.
Can you define the definition of live?
Well, I said occupy, have your furniture there.
Occupy, then that will consider it a storage unit because you can have furniture in a storage unit and not necessarily live in it.
All right, and you don't, it's your position that you don't have to pay to store your furniture.
It is my position that I went into an original lease agreement to be able to live in the home, meaning I would be able to sleep in the home overnight for the remainder of the lease, and that was breached by the plaintiff not keeping the home in habitable security.
And that was for 4730 or 4732?
The key that I was given is for 4732.
All right. So your position is though that there is not a formal lease for 4732?
That is correct.
All right. And it's your position that the lease that you signed for 4730 was not transferred to 4732?
A new lease was not created, meaning a new signature would have to have been created with a new timestamp and a new date.
All right. But you moved into 4732?
I was given a
Correct.
key. I was given a key, and I walked to the 4732 unit without a representative for Hunter Townhome.
Moved to strike as non-responsive, Your Honor. The question is, did she move in or didn't she to 4732?
Did she move into 4732?
4732?
I did.
Right. And you have furniture still at 4732, correct?
The furniture is at 4732.
That's the answer to the question. It's a yes or no question. Thank you. And it is your furniture that is there?
It is.
All right. You paid rent for 4732 for August of 2022, correct?
That was the initial move-in. Upon moving in, before I could move in.
The yes or
I
no
had to-
question, ma'am. You
upon
get a
moving-
chance
I'm gonna
to
let her
testify later.
explain.
Prior to moving in, upon moving in, I had to pay a $250 deposit prior to August. And then I had to repay a remainder balance of $1881, August 1st of 2023, in order for me to get a key to move into one of Hunter Townhome's properties.
I think you meant August 1st of
August 1st,
2022.
August 1st of 2022.
All right.
I was
And
given a key.
did you pay rent in September?
They received a letter for all of the allegations, including asking for an updated lease. And someone from their Hunter's property management signed because I needed it was certified mail.
I'll ask the question again. Did you pay rent to Hunter Townhomes in September?
I paid rent there. I put their rent in escrow, in
Into what
Fidelity
bank?
in escrow, and Fidelity Investments.
All right. And what was the account number?
That will be given upon further investigation or as needed. I do not feel that I have to provide you with the account number. However, I can provide you with a copy for other.
Did you provide the landlord with the account number?
No, that is not their, it is for me to give them the money. It is not for them to take the money from my investment account.
Did you tell them where the escrow account was located?
In the letter, I did.
All right, but you did not provide an account number so that they could confirm that, did you?
No, I did not.
October's rent, did you pay it, yes or no? To the landlord?
October, for lack of valid rental certification, no.
Right. And did you notify the landlord that it was being placed into escrow?
They received a letter.
Did you provide them with the location and the account number of the escrow?
That was not needed to be given at the time.
And that's based on what, just your opinion?
That is the law. At the moment, they do not need my account numbers. They need proof that the money is in escrow, where I have a screenshot of 1520 in an escrow account.
I'll respectfully disagree with you, but we'll let the judge decide that issue as to what the Michigan Landlord Tenant Act provides. November's rent, did you pay it into escrow?
There is no valid rental certificate. There was nothing to be put in escrow. Again, I asked and wrote a letter in September. Actually, I asked in June for the lease to be updated. It was not. Therefore, I asked in a letter in August, and I also asked in September for the lease to be updated. Therefore, it's not. Therefore, Hunter Townhomes essentially dismiss their ability to be able to collect rent due to not filing or filling out the correct paperwork in order for them to receive proper paperwork. If you're gonna go off of black and white, sir, I'm sorry, if you're going to go off of black and white, and if anything is to stand up right now, I have proof that I requested for the lease to be updated, and if we are under contract, there is no valid contract. What there is a key exchange.
Once again, that was a yes or no question. All right. Did you notify the landlord that you had placed rent into escrow for November? Yes or no?
I believe I just answered that.
All right. So that's a no, you did not notify
I
them?
plead the fifth.
Well, I don't think that there's any allegations of criminal activity.
Well, it's
So I guess I would respectfully request that the judge, Your Honor, that you order her to answer.
The Fifth Amendment right is your right against self-incrimination. This is a civil proceeding.
Okay, so it's not gonna affect me down the long run. There was no valid rental certification. No, the rent was not put in there because of lack of valid rental certification. There was no rent put in escrow for
Right, that's,
November,
and you've answered
December,
the question. Thank you.
January, February, March, April, up until this point, because the furnace has not been fixed and there is no valid rental certification. There's no contract of any monies owed or any monies to be deposited into a
Ma'am,
escrow account.
have you ever gone to law school?
I am very smart.
All
I
right,
do
I'm
not need to go
I'm
to
not
law
disagreeing with
school.
that. Are you a licensed attorney?
I am not, but I do have the same brain that you have.
All right. But without the benefit of 3 years of law school training.
What is the point of this line of questioning?
The point is I'm trying to find out under what authority she is making these pronouncements.
I'm
Right?
under-
What is the legal basis for her
She doesn't
to?
have to provide a legal basis for her pain.
All right. Even as you did not put any money into escrow from November forward, your furniture has continued to occupy the unit, correct?
Correct. And
Isn't it
Hutchinson-
also, ma'am, isn't it also true that 4732 Duvernay Drive has never been, during your tenancy, during the time that your furniture has occupied it, has never been pink tagged by the city of Lansing? Isn't it true?
The unit has not been pink tagged to my knowledge.
The unit has not been red tagged either, correct?
The Pacific unit, no, it has not.
And isn't it true that the property has been specifically informed by the city of Lansing? It's not in violation to the point where they would be prohibited from renting or leasing it out. Isn't that also true?
I cannot attest to that because the property also has other buildings and units, so I cannot attest to that. I can only specifically speak for 4732 and an invalid lease for 4730.
Have you spoken with anybody from the city building department about 4732?
I have not.
Have you received anything in writing from the building department at 4732 indicating that it can't be rented?
I have received notification from Hunter Townhomes that they were coming in to do an inspection. And upon going to the office the following day for the inspection results, no inspection was conducted.
Move
And
to
this
strike
is
as
all May
non-responsive,
20.
Your Honor. I asked if she had communications with the city, with the building department.
Did you have communications with the city?
I did not.
You submitted a work order on or about August 15th of 2022. Is that correct?
That's what you have.
All right. And isn't it true that that work order was responded to?
The work orders that I have right here are for August 25th, August 26th, August 31st. There is an okay to entry on August 25th. There is an okay to enter on August 26th. And there is a no okay to entry on August 31st. The August 25th status of this work order was canceled for an active leak in the bathroom. The service order for August 26th was canceled, and this was for a broken light fixture that was hanging up at the top of the stairs where possibly insects could get in the home. And the work order for August 31st is completed, and only the description is main request form. The problems on here: patio screen doesn't slide, hallway bathroom sink lifts up, bathroom toilet seat lifts up, out of cabinet needs covering in the bathroom, sinks leak, smells bad on the floor, toilet seats broken, residue, new filters for the furnace, leaks, toilet leaks, broken glass.
Once again, we're
broken
getting
light
far
fixture.
afield. It was a yes or no question. You didn't mention any of these things you've just read out, though. You didn't mention any of them in your answer to the complaint, did you?
the answer and complaint is the judgment is for monies owed. And therefore I've specified why there was in the letter sent out on August 31st, why the money was put in escrow.
No money judgment being reflected on its possession judgment.
Possession judgment came, and therefore because I was not put out of the
Again, it's a
home.
yes or no question. The pleadings that you filed with this court, your answer and affirmative defenses, this list of items that you have just read off, none of them are mentioned in your answer or affirmative defenses, correct?
Correct.
All right. And in fact, the only item that was listed in your affirmative defenses, and it's affirmative defense number 16B, right? It was furnace only. Anything else listed as far as an alleged defect other than the furnace?
Before you go to B, can you notice that 16A, that the furnace blower started to go out at the end of September? Before we get to B?
I understand what you have written
Okay.
there. The question is not what is written, it's what's not contained there.
So what is not contained there is for reasons that I placed in the letter of why the rent was being put in escrow for the lack of maintenance to be able to come in, and for Hunter Townhomes to keep up the property for it to be habitable. With having 4 kids, I don't think any of those things are habitable, along with broken glass mirrors.
And once again, ma'am, I asked you a yes or no question. I didn't ask why, right? And I just want a yes or no answer. All of these other items that you have now talked about today are not in pleading that you submitted to the court.
Not in the pleading, but Hunter Townhome received them, so no, they are not in the pleading,
All
yet
right.
Hunter Townhome has a copy of them.
You've answered the question. Okay, you're going into all sorts of extraneous responses.
To give you to,
All right,
sir.
I'm asking you a yes or no question. You're welcome to testify about details later. The work order from August 31st, isn't it true that by October 14th, the work was completed? Again, this is a yes or no question.
Well, you're gonna give me time to look through those maintenance requests.
So it's a work order from August 13th.
Correct.
Work or order from August 13th or
I'm sorry, August
October?
31st.
August 31st.
That's my error. I got the numbers transposed.
What was the work order for?
It does not say its completed date. It says, I'm unaware of 3 visits and we are not going back. They asked to leave every time. I'm unaware of 3 visits. I'm unaware of 3 visits because any maintenance list, because the first 2 they had okay to entry. So I'm unaware of the technicians knows 3 visits and we're not. And we are not going back. They asked to leave.
Maintenance will testify to that. That's fine.
Why was there a work order for August 31st?
It'll be introduced into evidence.
Okay.
There's a work order allegedly dated September 13th of 2022. Isn't it true that work order was completed on September 13th of 2022? Yes or no?
I do not have copy or notification of a work order in September.
Isn't it true that there was also the second work order submitted September 13th that was completed, that was taken care of by September 22nd?
Can you verify how those work orders were put in? Because I don't have that. And when I
With all
went to
due
the
respect,
office-
ma'am, I'm the one that gets to ask the questions right now.
Okay, with all due
Okay, If
respect, I have no
you can't answer, that's fine. If you don't know, it's okay to say you don't know.
I have no answer to that.
November 8th, there's an alleged work order that you submitted, and it's also allegedly completed November 10th of 2022. Isn't that correct? Yes or no?
There is no work order for November 8th. The work order that I have for November is for November 10th. It says completed, but it does not have a completion date. And I have a work order for November 15th. And this, however, does not have a completion date.
All right, how about a work order Number 178523, submitted November 22nd, completed on November 28th.
I have this work order. It does not have a completion date. And this was for outlets in the living room not working and the dryer not working either.
All right, and there was one December 14th that our client claims was completed December 15th. Is that correct?
There is a work order for the December 14th. I am noticing, however, for all of these work orders, the okay to enter says a yes, so I'm unaware why they didn't enter any other time or why they wouldn't come back in. So I do not have a completion date. I see, only thing that I can see is the problem description. I can see if it's a high or no or low priority. I can see if it's okay to enter. I can see if anyone is sick. I can see a phone number and I can see a status.
Well, I'm also asking based on your knowledge and your recollection. Based on your knowledge and recollection, or I'll ask it this way. Do you have in your possession any work orders from January?
So we were just talking about December, now we're in January?
Yep.
January now. In January, I received a master
Not the question,
policy.
ma'am. The question is, did you submit any work orders in January? Do you have copies of any work orders you submitted in January?
All of my work orders were submitted verbally. Therefore, I had the only copies that I have of work orders with slips are what I was able to get from Hunter Townhome Properties.
All right, and so the last one then is from April of 2023, which my client also claims was addressed on April 3rd, the same day that it was submitted. The last one that Hunter Townhomes has in its possession. Do you have any other work orders other than those I have just gone through?
I am missing some of those work orders that you said. I have the April 3rd work order. However, they have entered into the home recently without no person to entry or no denial to enter.
Do you have any work orders that we have not discussed?
At the moment, I only have 100 townhomes gave me.
All right.
Can you give me that date for October again?
Sure.
And can you also describe what those notes are?
Actually, I don't have any for October. So
I
let me ask
have
you
this
about
for October 6th, and they put a slip, said no person to enter. If this is at the door, why would there have been a work order submitted? Or if this is at the door, why is there no work order submitted to go along with this tag?
I believe it's the work order from August 31st, which was addressed on October 4th.
I received
But
this.
finally addressed October 14th.
I received this October 6th, and that's why the date is on here.
All right, that's fine, because they'll testify it was addressed by October 14th.
With no work order? With no
Work
copy
order
of the
one
work
is-
I
order
believe that's from the work order.
Work
from
order
August.
173498.
that was being completed in October, so it took two. Okay.
Which is fine, as long as it's a reasonable time.
Okay, this isn't a
I
time
know,
for
I
back and forth argument.
I
One
understand.
of you did go to law school, so you know that.
This is true. Isn't it true that with respect to the furnace issue in November, that the thermostat was turned off, and that is why the furnace did not work?
That is not true.
All right. You'll have, do you have any expert to testify to that effect today? Yes or no?
I have photos.
And just so that I I have this clarified correctly, you are holding in your possession the key to 4732, correct?
Correct.
You have a claim, you have a counterclaim in this case for lockout, claiming that you were locked out of the premises which you were somehow entitled to.
There's no-
Is the lockout for 4730 or 4732? Either one.
There was as for the counterclaim, it is to prevent me from being locked out until the end of this case. I did not say that I was locked out. I want to prevent being locked out until all belongings are moved from the property.
And for 4732, correct?
Correct.
All right, just so we have that clarified. Your Honor, I have no further questions of Ms. Milton at this time. I reserve the right to cross-examine her after she presents her case.
Okay. Are you calling any other witnesses?
Yes,
Okay, I'm not gonna have her present her case in chief yet.
understood.
Okay.
Understood. Plaintiff calls Beth Pitts, Your Honor.
You raise your right hand. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury. Thank you. You can have a seat there. There's a microphone in front of you, and the lady behind you is the court reporter. She has to take down everything being stated here today. So your responses need to be loud and clear because these plastic things block the sound a little bit. They need to be verbal. Head nods and shakes cannot be written into the records. We need to hear an audible sound, okay? If there's an objection from either party, you would stop answering. I'll make a ruling on the objection, then I'll let you know if you can get that response or not, okay?
Yes.
Please state your first and last name and spell both of them.
It is Beth Pitts, Beth, last name is Pitts.
Ms. Pitts, where are you employed?
I'm in the administrative office. I do the bookkeeping.
For what company?
Oh, sorry, Hunter Properties.
In the course and scope of your employment at Hunter Properties, have you become familiar with Ms. Milton?
Just with the past due account.
All right. And her account is past due?
Yes.
All right. I'm going to show you what's in the process of being marked as plaintiff's proposed exhibit 1 and ask if you can identify it.
Yes.
What is that document?
It is the resident ledger for Jasmine Milton at the address of 4732.
And is that a document that's maintained in the ordinary and usual course of business at Huntertown Properties?
Yes.
And is a copy usually maintained in the tenant's file?
It's in the computer.
All right, and it was printed out in preparation for today's trial, is that correct?
Yes.
Your Honor, subject to any voir dire or objection on the part of the defendant, plaintiff moves for the objection, or moves for the admittance rather, of proposed exhibit 1.
Any objection to proposed exhibit 1?
No.
Okay, all right, it can be admitted and you can publish to the court. Is your exhibit?
It is.
Okay.
Ms. Pitts, what does the ledger show as the current balance owed by Ms. Milton?
$17,172.53.
And that's based on rent being charged at $1,500 a month, correct?
Yes, base rent at $1,500.
And when does the ledger reflect the last payment having been made by Ms. Milton?
August 1st of 22.
Of 2022.
Yes.
To the best of your knowledge, does Ms. Milton's file contain a letter indicating that she was going to place her September and October rent into escrow?
I don't believe so. I've not found that.
Did Ms. Milton ever provide you directly with a financial institution and an account number containing rent escrow payments?
No.
Now, Ms. Milton has raised in this case affirmative defenses, specifically that her furnace did not work. What is the procedure for submitting work orders?
You can either go online or call the office, and then if they call the office, we will put it in for them.
And when a work order is received, what then is the procedure to address it?
Maintenance tech will go out and then assess the situation.
I'm going to show you what has been marked, or is going to be marked as plaintiff's proposed exhibit 2. I apologize, Your Honor. I have multiple copies of the same exhibit, and I'm trying to get them into the right category here. I will ask you this in the interim, Ms. Pitts. In the time that you had, how long have you worked at this particular location?
20.
And since October of 22, has 4732 or 4730 DuVernay been pink tagged by the city of Lansing?
No, it has not.
Have either 4732 or 4730 been red tagged by the city of Lansing?
No, not to my knowledge.
Have you been advised at any point in time by the city of Lansing that the premises could not be leased
No,
or could not be occupied?
no.
I'm going to show you what's been marked as plaintiff's proposed exhibit 2. They ask if you can identify it.
These are work orders for 4732.
And to the best of your knowledge, were those work orders submitted by Ms. Milton? If you know.
I don't believe it shows who actually submitted the work order. It just shows the person and the unit and the problem.
All right, it does.
I couldn't.
As I look at it, there's a caller name on the third of the way down page on the left.
Let me stop you real quickly. Are these potential witnesses?
Yes, they are.
I'm gonna order sequestration. Back on the record.
Thank you, Your Honor. Ms. Pitts, the question was, is there anywhere on the work orders where there is an indication of who submitted the work order?
Yes, it does say caller name.
And for each of these work orders, who is listed as the caller?
Jasmine Milton.
When is the first work order dated? I think the date.
8/25/22.
And the last one is dated when?
In the filing date.
The very last one, the last page,
Oh.
the last work order.
I'm sorry, this was 8/31/22.
Okay. If we go to the end of the work orders,
Yes,
okay? When is the last one?
I'm gonna ask you a question. The last one of total occupancy?
No.
Okay.
Work order, in the upper right-hand corner, there's
Yes.
a work order number and a date call.
Yes,
Okay. If we go to the last page of this set of documents,
got it.
when is the last date
Oh,
call?
I see what you're asking. Sorry. Yes, it's 8/26/22.
All right.
Sorry.
And these work order records are kept in the ordinary and usual course of business. Is that correct?
Yes,
And again, it's in the computer system reference to each tenant.
yes.
Your Honor, subject to any cross-examination or objection or voir dire on the part of the defendant, plaintiff moves for the admission of Exhibit 2.
Any objections to Exhibit 2?
I asked a question
If you want to ask about the exhibit,
about the ledger.
no, this is about the Exhibit 2. Did you show her what
Oh.
Exhibit 2 was?
I have.
I wasn't, it wasn't made aware that this was the exhibit 2. Okay.
So my question is if you have an objection to that as an exhibit.
Oh, I do.
Oh, what is the objection?
The objection is, I'm unaware of these okay to entries. Some of them say yes, some of them say no. I'm unaware of why. And I'm just unaware of these, how it's determined whether it's okay to enter or not, and whether a tenant says it's okay to enter or not, at what point does Hunter Town enter or not?
Okay, so your objections are really more clarifications that you can probably cross-examine her about, and not actually objecting to whether or not, yeah, this is a log, correct?
Yes.
That's kept in the regular course of business. So your objection is overruled because I think those are questions that you probably want to ask her when you cross-examine her, okay? So that Exhibit 2 is admitted.
Thank you, Your Honor. Please mark as proposed Exhibit 3. Ms. Pitts, I'm going to show you what's being marked as plaintiff's proposed Exhibit 3 and ask if you can identify that.
More work orders for Jasmine Milton.
All right. And the first work order, the date of the call is when?
9/13/22 at
And-
12:08 p.m.
And the last one is dated when?
4/3/23 at 11:49 a.m.
And again, these documents are maintained in the ordinary course of business by Hunter Townhomes,
That's correct.
and they are in the computer system, and they're cross-referenced by tenant or by property address. Is that correct?
That is correct.
Your Honor, again, subject to any voir dire or objection on the part of the tenant, we move for the admission of plaintiff's Exhibit 3.
Any objection to Exhibit 3? You can review it first.
believe these are all the work orders, but no objection.
Okay, no objection as to the exhibit 3. That's admitted.
Thank you, Your Honor. Ms. Pitts, with respect to, I realize there's a work order here that there's an indication that maintenance attempted to repair and was not permitted to enter. Are there any of those work orders that show that there was no effort whatsoever to address the issue?
You're talking in exhibit,
2 and 3.
so I'm making sure. There was one work order on 11/10 that they did not, they put in here that the dryer needs replacing, but they did not want to replace at the time because of such an outstanding balance.
All right.
Yes.
So other than that one situation,
Right.
and I think if I recall correctly, looking at the exhibits, the other one that didn't get resolved almost immediately was the August 31st one that then notes on October 14th that there had been attempts, but refusals of entry. Otherwise, other than those two, is it correct that efforts were made promptly to address the repairs?
Yes.
And looking at the work orders, there are work orders submitted during periods of time that Ms. Milton claims that she couldn't reside in the property. Is that correct?
That's correct.
I'm going to show you, I'm going to have this marked and then show you what's being marked as plaintiff's proposed exhibit 5. Can you identify that document?
These are memos.
I'm sorry. You still have 4? Is that what's going on? Because you've not proposed.
I'm
a
sorry.
fourth.
I did not realize.
Didn't know if that was intentional.
I don't think that Ms. Milton objected, and plaintiff does move for the admission of exhibit 4.
We don't have 4. We only have 3.
Oh, okay.
So this one you want
this will
4?
be 4 then.
Okay, good.
And do you recognize that particular document?
Yes, this is a memo board that goes on each resident. So if they call, if they have something going on in their unit, we can log it.
And it's not a memo board like
No.
this on the wall over here.
No.
It's a computerized memo board that's
Correct.
maintained.
Yes.
Is it maintained in the ordinary and usual course of business?
Yes.
And again, is it divided by tenant or property address?
It is both. It's under the property unit number and then the current resident living.
And for which resident is this memo board maintained?
This is for Jasmine Milton.
Your Honor, subject to any voir dire or objection on the part of the defendant, we will move for the admission of plaintiff's exhibit 4.
Any objection to that exhibit?
Let me verify that all the memos that they have listed on here are all the memos that I received.
Wait.
I object, Your Honor. I found some other ones that they do not have a listing of all memos that were given to me.
Was this supposed to be a document that represented all the memos?
No.
It says,
No.
it says a memo information, and it starts from August 31st, from when they got my consumer's confirmation number. Then on August 15th, they have a memo that I called today stating that I was upset that my townhome on the day of move-in, and told them I informed that I will not be paying rent until my townhome gets fixed. And then it goes to September, October. There is no memo for this, for November, but I have a memo for November right here. So I do object.
Your Honor, I think that would be a topic for cross-examination. I don't think it goes to the admissibility of the document itself.
But the document is incomplete. It does not have all memos sent to me.
Okay,
Listed.
you should cross-examine her on that, okay?
Okay.
Okay, with objection, I'm gonna overrule and admit the exhibit.
Okay.
Thank you, Your Honor. Ms. Pitts, what is the date, by the way, of this particular document?
The last memo date was 3/20/23.
So if there were any further memos issued past that date, they're not reflected on this document. Is that correct?
Correct.
And these are internal memos pertaining to the client, not documents issued, or I'm sorry, strike that. These are memos relating to internal issues relating to each tenant rather than letters that may have been sent to a tenant.
That's correct.
So there may have been other communications with Ms. Milton that are not reflected on this memo board.
That is correct.
All right. And she'll ask you about them, I'm sure. At any time, did Hunter Townhomes waive any of the rent that is claimed as due and owing by Ms. Milton?
I don't see any waived for that.
Right. And are there any charges based on Exhibit 1 that Hunter Townhomes believes are inaccurate?
We had one on 10/17, but on 10/18, we made the adjustment and already put the credit on there right after.
Otherwise, the ledger is accurate as it exists.
That is correct.
You authorized the issuance of a 7-day notice to Ms. Milton, is that correct?
Yes.
And it's attached to the plaintiff's complaint. I will show it to you. That's your signature on the 7-day notice?
That is not.
Okay. Do you know whose signature that is?
Yes, that is Roxanne Pettis. She was our property manager.
At the time.
Yes.
And that's as of October of 2022 when it was issued.
Correct.
And as Exhibit 4 reflects, 7-day notice was issued. Was any payment made during that 7-day time period?
It was not.
And at that point, did Hunter Townhomes authorize the filing of this particular action? Your Honor, I have no further questions of Ms. Pitts. I yield the floor for cross-examination.
You can cross-examine at this time.
Can you tell me your name again?
Yes, that.
Elizabeth? Okay.
Yeah.
Elizabeth, can you tell me what's the proceedings on adding all the memos for each tenant?
It's a manual entry, and if we find that it needs noted, we put it in there. If someone calls having a complaint like you did on 8/15/22, we opened up the memo board and put it in. So you gave us your consumer's confirmation that you put the gas in your name at 4732. That utility was in your name, we put that in there. When the 7-day notice went out, that went in there, and then filing your eviction, attempting to contact you to leave a message. I believe that would have come from the property manager. And that was usually a voicemail, but these are just internal memos of what we're trying to do to resolve the issue.
And when you send out these mass letters to each one, is it not noted in their account of all mass letters sent out?
It does not automatically upload mass letters.
So it's selective.
No, if the leasing agent wants to manually enter that for every single resident into that account, that is the only way to do that.
So it's wanted, it's not necessary that all memos are entered, it's only the desired memos, not all memos given out, correct?
It's only ones that are pertinent.
Pertinent, yet all letterhead letters are not pertinent to an account to be, okay.
Maybe
I
not
have-
to your particular situation.
Okay, just speaking overall for Hunter Lansing property, when you guys go and make these memos to these accounts, why are all memos not mentioned? I do have an account, I have a memo from November 21st of 2022, January 10th of 2023, May 5th, May 23rd of 2023, and then of June 21st of 2023. So there are 4 memos that Hunter Townhomes deemed not pertinent to my case, correct?
I have not seen those memos, so I don't know what you're referring to.
They are letterheads from Hunter Townhomes, if you would like to look at them.
Are you gonna make these as exhibits?
Okay, and if I give these exhibits, do I have to give them to all parties? So at the
You do
moment-
have to, yeah, you need
Okay.
to show him what the exhibit is.
So I can just ask questions right now because I do not have copies of all the exhibits.
Okay, so you want to admit memos as exhibits, is that what you're trying to do?
Mhm.
Yes, you have to say yes or no on the record.
Yes,
Okay, and you have 2?
I have 4. And it looks like,
Or are you using it to then refresh your recollection? You don't have to admit it. as
yeah, I'm
exhibits.
using it to reflect recollection because the May 22nd memo
Okay.
is specifically designed to 4732, but it has not been submitted on the memo line.
Okay, you want to show her counsel what these memos are.
There is another memo put in
Let
on
me let
March.
me just ask, would seeing any of these memos help refresh your recollection about these memos she claims are missing from the
Not
log?
necessarily, since I'm not the one who issues them,
Okay,
Can you,
but I wouldn't mind looking at it too, so I could say what it could be.
can you verify who does send out these memos?
It depends on the situation.
Okay, for the mass letters that go out to everyone, who is in charge of sending out those letters?
Depends who it's assigned.
Okay, for the townhomes, for my building specifically, for 4732, who would be assigned to send out memos?
It depends on that day, who's working.
Okay, so there's no specific title of a position? So it wouldn't be the manager, it wouldn't be the maintenance man, it wouldn't be the leasing agent, it wouldn't be a outsourced contractor that would come in and deliver these to 4732 or any of the properties? It's all based on what's going on in the office that day? No specific job title?
I'm not exactly sure what you're asking. Who's writing the memo or who's delivering the memo?
Who is assigned
Mhm.
to write and send out the memos
Mhm.
that are sent to 4732, since you are unaware of
Can I
who does
see
it massively?
the memo? It depends what it's,
I'm not sure it's actually a memo based on what I saw, but the one that I saw.
It looks like,
Looks like that would be a mass letter.
for the March 20th, are you looking at the March 20th one? Oh, this is the March 20th one. Let me swap you out. The March 20th one does have my name and address on it, and it is listed here in the memos. However, this May 23rd one that also has this address on here is not listed on the memo.
So
Okay,
the-
so-
The memo list, however, was dated March 20th, so
sorry?
anything after March 20th would not be
I'm
on.
still. one
Okay,
moment.
just wanted to
One moment.
bring that to your attention.
In this November 21st, can you verify that that is 4732 Duvernay? Does the address on there say 4732 Duvernay at the top left corner underneath?
yes, it does.
And they is not mentioned on this memo, this exhibit that was submitted by your attorney. So those are all specific memos sent directly to 4732 in Hunter
Mhm.
Townhome, has no recollection of who sent them, what position, on what day, what time, or nothing, correct?
So this one is on the memo list. Would you like to have it back?
Yeah, I'm clarifying.
What's the date on that one?
This one is March 20th. In regards to pet waste, and I do not have a pet. I have pictures of that day that I seen the letter and took pictures of my grass, and there was no pet waste there.
So the March 20th, March 20th is reflected on this. So as to the other one she has, the question is what as to those two?
Why as to those two that have my address, I'm trying to get down to
why they're not reflected on this.
why
list.
they're not reflected on the memos notes. That's what I'm asking, because it looks like this memo for the tenant of Jasmine Milton. I would believe that anything that had.
Well, let her tell why. You don't tell us why your argument as to why.
So there's a different memo area that's just on our front page that just has that a DNR that says do not renew. And anyone under eviction is obviously not paying, so they're not renewable. And this is just we will not be renewing your lease, and it was a courtesy note just so that you could find other housing.
Okay.
We gave it to you in plenty of time.
All right. So upon that 7-day notice being sent out and the unit was not evacuated, why did Hunter Townhome not proceed with further eviction? Why did they not remove all properties from the property?
Excuse me?
Why did, after the 7-day notice and there was a high balance, why did Hunter Townhome not proceed with removing my properties from the home?
Because that's illegal.
They have to have a lawful eviction.
Okay.
Sorry.
Oh, just making sure. And there's no note for this one. I have a move out date letter, right? Let me ask you something. Do you recognize these signatures?
I wear bifocals.
That's fine.
Maybe it says Dakota.
Dakota? That's what I
Maybe.
got. Okay.
Maybe.
All right.
Not very legible, but I would assume it's someone in the leasing staff.
So this signifies that any letters sent on this date above, can you read that date?
It is 9/8 of, right, 22.
And this signifies that Hunter Townhome did receive the notarized letter.
So we received something.
You received something, okay, but it doesn't specify what you
It does
guys
not
received.
say what we received.
All right. Can you verify how Hunter Townhome determines whether Hunter Town is able to enter into a property or not enter into a property if maintenance is needed to be fixed?
If you put in a work order, we'll come out and fix it.
And then if it says no, do you guys still enter in the property?
If it is an emergency, a water leak, something, we're gonna enter anyway, absolutely. Because you have to prevent mold.
If there are no rental, if there are no work orders submitted, what discretions allow for Hunter Townhome to enter into a home? If there are no work orders submitted.
If we are not receiving payment or communication, we will go to the unit to determine actually if the resident is unwell, there's a health risk, is it an emergency, or have they actually just moved out?
Do you guys have documentation of each time that you enter into a home? Do you guys have documentation for each time that you've entered into 4732 to determine after the high balance if the home was livable or not?
Are you asking if we entered the unit or if it was livable?
I'm asking if you have a record of all the times you guys entered into the home without a work order to determine if the home was livable or not.
No.
No, you
we
do
just
not.
have the one where you showed me the letter a moment ago. Where we were
Okay,
coming
so
out.
you guys are able to just enter into the home. And if you guys see that it's livable or not, so it's, okay.
If we walk in and there is furniture, we just turn around and walk back out. It is obviously still occupied.
Do you guys have a licensed technician that can understand HVAC and thermostats on your maintenance team?
Yes, and what is beyond that is we have a licensed contractor.
Are they able to determine if a thermostat is working or not?
Yes.
If a thermostat is not or is working, and what are the next steps to be taken? If a thermostat is or is not working?
Are you saying if it's not turned on?
If it's not working, if it's unusable. It's on the wall, correct. If the thermostat is unusable,
Okay.
at what point do you guys determine that further assistance are needed?
Normally, if the thermostat on the wall isn't working, you would change the batteries or put a new one on.
Do you guys have record of changing batteries or swapping out the thermostat for 4732?
You have work orders that address that.
That the thermostat was completed or that it was off? Note that as of yesterday, the thermostat is still not working.
I think he's gotta answer your question first.
Okay, I'm sorry.
So you are still living in the unit?
Well, you don't get to ask questions,
Oh,
ma'am.
sorry. I'm just, sorry, I was just.
I'm asking that, in regards to the thermostat, what do you guys do when it's not working? What are the proceedings on moving forward?
We check it for changing the batteries or change out the thermostat. And we do have a work order that says that it was just off and it was turned on.
Okay, so one of those you did state that there was a work order for the dryer and you guys did not, Hunter Townhome did not change out the dryer due to the high balance. At what point in the, at what point is it decided that no work orders are gonna be done when there's a high balance completed? Because one
That's
was
just
not.
a dryer but all the rest of your work orders were taken care of.
Okay, the furnace, with the furnace still being out as of today, what notes do you guys have on
the last time?
Wait, objection assumes facts, not an evidence.
Okay, there's an objection because there's no evidence on the record that would substantiate your statement that as of today, the furnace is still out. So she can't answer that question without that being. You can first ask her, though, is the furnace out?
Is
as
the
of today?
furnace working in 4732?
I will assume yes.
Assumption.
Well, I have no idea because there's no work order placed.
There's no work order placed. Okay. So with you not having anything for the work order being placed as of now, can you tell me the requirements on if anyone enters into a unit, are they to leave notification that they entered into a unit?
I believe that they do leave a notification.
It's not set in stone, it's under a belief, it's not in the.
Well, I think the question was, is there a requirement?
Is there a requirement for Hunter Townhome to leave a notice that they entered into a property?
Yes, but if we've already notified you we're coming out, they might neglect to do that because if they're out there with the city inspector.
I hear might and but, not certainty.
Okay, but I need clarification now. Is there a requirement for them to leave notice when they enter?
Yes.
Okay, thank you.
Okay. So it is to say that upon recent entries there, and some of the missing entries over the dates that we have talked about, I do not have entry notice that they.
You can give testimony about that, but you're asking her questions.
Okay. Can you? You said that in an emergency, they are able to enter into the home. At what point is a balance deemed high where Hunter Townhome will not fix anything in the unit? What is the dollar amount?
That isn't a question I can answer.
Okay. So the dryer wasn't completed due to a high balance, which you are unaware of what the high balance is in order for Hunter Townhome to complete their work orders by obligation?
You're asking for a specific work order that was declined on a general basis, and that isn't the question.
Is there a set amount? Do you have a general amount
No.
of money that you guys use? So then I can say that it seems that Hunter Townhome determines what to fix and what not to fix at their leisure because there is no tracking, correct? Outside of when a work order is submitted.
You're assuming a general situation off of just one work order.
Oh, so what is the standard as to when Hunter Townhomes determines that they're not going to make a repair?
I don't have an answer. This was determined by the maintenance supervisor. I don't have it.
Previously made a testimony about it, but now you don't know.
Well, if you're asking for a dollar amount,
Do you have a dollar amount?
I don't have like a specific dollar amount. No.
Okay, so is it case by case?
I would say it's case by case.
Okay.
But you are unaware of what dollar amount deemed for Hunter property management to come in and fix the furnace?
Furnace is an absolute basic necessity, so.
So that wouldn't be denied, is what you're saying, based on the dollar amount?
Correct.
That wouldn't be denied.
But let me get clarification, but something like a dryer might be denied, is what you're saying?
It sounds like it was on the work order for this case.
But that's a question better suited for maintenance, is that what you're saying?
I would say that maybe that is better for maintenance to answer that, but.
Thank you.
So upon moving into a unit with Hunter Townhomes, if a washer and dryer, furnace, refrigerator, oven, stove, everything is listed in the unit and that is included in the rent, at what point are they to fix it? With it all being included and to make the home habitable?
Your Honor, I'm going to object. It's a compound question. B, it assumes fact not in evidence.
Well, this is a hypothetical. I don't think she was saying that those were things that were, she's saying that if those things are included, at what point do they believe that they need to repair it? So I think that's a valid question.
Well, I think there's a difference between repairing and habitability. That's the point that I'm trying to make. She asked, at what point would you make a determination as to what's needed to make it habitable versus repairing? And I think there is a definite distinction in case law between the two.
Okay.
Okay, I'm sorry.
As to your objection as to the way the question is termed, I will sustain it, your objection, and have her re-ask her question without addressing the habitability. Separate it, because you make it compound when you do that. Compound meaning you make her have to answer more than one question at the same time.
Okay. What is deemed habitable to sustain a unit for a Hunter Townhome for a person to pay their rent? What is deemed habitable to be in use? What is deemed in order habitable to make a space habitable?
I think she heard your question.
Yeah, I'm sorry, but I'm just trying to think. Well, you need windows, doors, the water must work, gas, electricity, but those things are also for you to put in your name, which you did.
Windows, doors, and electricity in the state of Michigan. Only windows, doors, and electricity is deemed habitable in the state of Michigan.
I wasn't done.
Oh, sorry. I'm taking note.
The, like I said, you need to have functioning appliances in the kitchen, which we have no problems of those on any of your lists. Heat, air. I'm not sure.
Ma'am, are you aware that in September of 2022 that Hunter Townhomes came in to repair a blower for the furnace?
I'm sorry, I couldn't hear your response.
I'm sorry, I was reading the list. I have a 913 that a part was ordered, it's installed, they put a new board in. Is that not what you're asking?
Do you have the completion date?
New board installed on 9/15 of 22.
Because I think the question was, were you aware that
the blower went out and.
So that's a question that you need to be able to answer without looking through paperwork. If you need to be refreshed, then you let us know. But it's a yes or no question. Are you aware of that?
That they came to do the work order, yes.
You are aware that the blower and the furnace was repaired in September of 2022, 1 month after moving into the space, that the furnace blower was repaired 1 month later? You are aware?
Yes.
Okay. Can you tell me who completed the work order for August 31st? And what date was it completed?
If you can't tell off the top of your head, you can say that.
No.
Because you can
cannot
direct
tell
you to
me.
refresh your recollection if she
Sorry.
thinks it's that important.
All right, can you tell me who canceled the work order on August 25th of 2022?
No.
Can you tell me who canceled the work order on August 22nd of 2022?
I believe that one was Eric Foster.
Eric Foster canceled it. Can you tell me why Eric Foster canceled it?
Wasser,
Woster, can you spell his last name?
Wasser, I believe.
Can you tell me why he canceled it?
Well, first, do you know that or you believe it? So you believe it was him?
Right, I do believe that is my recollection.
Okay. And our next question is, can you tell her why? But do you know personally why? Or you have to speculate as to why?
When I read this earlier.
When you read what earlier?
When I read the work order earlier.
Okay, so you're basing your knowledge off reading what happened?
Yes.
Okay, you can answer.
Do you know why it was canceled?
They had canceled the very last one because they said they had gone multiple times and the resident had sent them away. Is that the one you're referring to?
Did they specify what the name of the resident was that sent them away?
Jasmine Milton, that would be unit.
They specified that?
They just said to the unit, so it says Jasmine Milton on the work order.
Is they Eric or multiple parties?
I will say it is Eric.
So Eric himself got a verbal confirmation from me at 4732 on August 22nd, on August 26th at 10:10, I would have been working. He got a verbal confirmation from me that he could not enter into the home to make any repairs.
I believe you'll have to ask him that question.
So you have a belief, you're not sure.
Okay, she doesn't know.
Okay. So. On September 13th, for the heat not working, do you know who completed this work order?
Yes, that would be Phil Eckert.
Okay. Is Phil still working with Hunter Town?
Yes, he is.
Did Phil update when it was placed in?
Yes.
And what date was that?
I would have to refer to the work order.
Okay. Can you verify the amount right here for me? This amount right here?
What are you showing her?
I don't know what this is.
I'm asking her if she can verify an amount.
No, I said, what are you showing her?
Oh, this is a copy of the Fidelity Investments account.
Did you show her attorney?
Oh, I didn't know, sorry. This is not your copy, but for you to see. There is a balance.
Why are you showing this witness this?
I'm asking her to verify the amount to verify. Okay.
You can do that when you give your testimony. She
Okay.
can't verify what's in your account.
Okay, thank you. Okay, so you listed that some of the things that are able to consider a home habitable in Hunter Town home deemed 4732 habitable, even with after 1 month having to fix the blower. What is the required amount of time before something has to be fixed? What is Hunter Town home required time for a work order to be fixed?
Your Honor, I'll object to the form of the question. The work order for the blower was submitted September 13th. The repair was made September 15th. So I object to the characterization of waiting a month to.
The work order was submitted, is that correct, as evidence?
Yes.
Okay. You can state your question. What was your question?
What is the valid timeline for Hunter Properties to receive a work order in the amount of time that they need to fix it?
Depends on the work. Some are more complicated than others, or parts need work. Some can be fixed very quickly. That's very general.
Okay. Is there an update system if parts are needed to be ordered? Is there an updating system that Hunter Townhomes abide by letting the unit owner know? Is there a method for Hunter Townhomes to inform the unit owner that a part is needed or that it's gonna take longer to fix?
Are you asking about the resident or the owner?
I'm asking if Hunter Townhome, the owner, notifies the resident of a unit if there is a lengthy timeline needed to repair something, to make a home habitable. What is the time frame?
I do not know what their time frame is for the leasing office.
I'll object to the extent this
Yeah.
also calls for a legal conclusion since.
Yeah,
case law is
you
very
don't need to
clear.
interrupt you. I recognize only the court can make a legal conclusion as to what's habitable and what's not.
Okay, of course. Okay, that works. Is Roxanne still the property manager at the Hunter Townhome?
No, she isn't.
Okay. Do you know her end date?
Not off the top of my head, it's approximately February.
She was there from September to February, or is it October to February?
I don't have her work in front of me on work chart.
How long can you answer how long you've worked at Hunter Townhome?
Yeah, I started in October.
Was Roxanne there when you were there?
Yes.
Okay. Had you known how long she had been there prior?
Again, I would have to have her employee file in front of me, and I wasn't prepared for that. For the blower being fixed, does it specify what, I believe it's Phil, does it specify what Phil did in order to have the furnace working again? Does it specify what he did? It has his notes.
And what do they say?
Am I allowed to read them?
She's asking you, so I'll let you read it.
Okay. On 9/13, problem was put in his heat not working. The motherboard is bad, is Phil's notes. He ordered a new part, should be here Friday, will install then. Is that the work order you're asking for?
Yes.
Okay.
So just to verify, you guys are unaware of who drops off these memos. It's determined per day, per person, per shift.
Is that a question?
Yes.
And so what are we referring back to?
The memos you guys have, there's no specific job title, there's nothing specific to notify. There's no note taking of who and what.
Anyone in the office is, if they are asked to write a memo, they will write a memo.
Okay. Okay. Do you recall if Dakota still works at the office?
He does.
He does. Okay. Can you recall if Tyler still works at the office?
Can I have a last name?
Tyler's last name. I don't believe Tyler gave me his last name, and I have to refer to an email. Do you have a Tyler that works in the office?
We do not.
You do not have a Tyler that works in the office. Have you ever had a Tyler work in the office during your duration?
Multiple.
Multiple Tylers, okay. Do you have an Al that works currently in the office?
I'm sorry, who?
Al, A-L, Al.
Yes, we do.
You do? Okay. How closely do you work with the leasing agents if you are only to do the ledgers? Do you tell me what your position is again?
I do the administration in the back.
You do the administration in the back.
Accounts receivable, accounts payable.
Is that it?
Order supplies.
Okay.
What else would you like to know?
I would like to know how your position works with other positions within Hunter Townhome.
I am in the back office, so I do all the in processing. So as they are collecting checks, they bring them back for me to process.
Okay.
If someone gets behind, I send out the delinquency notices.
Okay.
So that would be in the accounts receivable.
Can you tell me as of today who is in charge of signing leases?
That would be Andrew Sebeski.
Andrew Sebeski, that's his name. And you have nothing to do with new leases being signed?
That's correct.
Okay. Do you know any information in regards to the move-in process?
I have not been here for the moving process yet.
For the upcoming move-in process that you guys have, because Hunter Townhome has already started to market their units,
Okay.
asking tenants to renew their leases back in November.
Mhm.
Do you know what the upcoming move-in process is going to be?
Are you saying prices or process?
Process.
Sorry. I'm not familiar with the front of the house.
So for accounts receivable, you're in the back office, but you're not aware of what goes in the front.
I'm aware that people move in, but I do not have a process.
You do not have a
list.
process list.
No, that is not my job to move people in.
Okay. Is Andrew the only one that moves people in?
He is the leasing manager, but I don't know what specifically you're asking. Are you asking into the computer move in, or are you asking handing keys?
I'm asking both.
That's a multi.
Okay, so for the handing key process, who handles that?
That could be a leasing agent at the front.
That could be a leasing.
Mhm.
Are you aware that on move-in day of August 1st of 2022, that there were 200 people in line to receive their leases?
Objection assumes facts not in evidence.
I asked if she was aware. Yes or no?
You don't know it's fact. She's asking if she was aware.
Are you aware that on move-in day of August 1st of 2022, that there were 200 people in line to move in?
I started working in October of 22.
So you're not aware?
I was not present.
Okay. So then you are not aware of the 5 stations that they have within the leasing office to get someone moved in. You're not aware of the
Once
5
again, Your Honor,
stations.
all objective assumes facts not in evidence.
It does, and she's already told you she's not a part of the moving process, so
Okay.
we can move on from there.
All right. Do you deem the valid, the rental certificate that we have, do you deem that valid?
I'm sorry, I didn't hear your question.
Do you deem the lease that is on file valid?
The rental certificate right now is expired, but the units are not tagged, and the city has said they are not uninhabitable.
Do you have documentation that the city has inspected all units of Hunter Townhome?
Your unit is inspected, yes.
My unit was inspected?
Mhm.
Do
Is that
you
a
have
yes?
what date that
Is that a yes, ma'am? You can't
Yes.
say, thank you.
Yes.
Do you have the date that the unit was inspected by the city inspector?
The city inspected it in 22. And we sent in our paperwork, I believe, June 1st, for the final inspection and to receive that certificate.
June 1st of 2022 or 2023?
Sorry, 23.
Okay.
June 1st? Okay, so to clarify, on June 1st of 2023, the city of Lansing entered into 4732 Duvernay and deemed it livable?
We completed our paperwork and sent that to the city.
So it's unaware if 4732, if the city of Lansing actually entered into 4732?
I have no idea if they entered. That would be the city.
Okay. And tell me again, your inspector, they came in on June 1st. What inspector was that came in on June 1st?
No, I didn't say we actually came into your unit. We completed our inspection form and submitted it on June 1st.
Can you tell me what is included in your inspection form that is submitted?
Anything that the inspector told us they wanted us to fix.
Can you give me an example?
I can, it's very broad. It could be that a utility faceplate needed replaced because it was cracked. It can be any and all things.
Okay. Who determines what units are to be inspected by the inspector?
The inspector.
The inspector determines the unit? Okay. Does the inspector look through any maintenance requests?
No.
Okay. So, okay. So no city of Lansing has inspected any Hunter Townhome property since August of 2022? No city inspector.
Are you
Has
talking
it-
about any of our properties?
Has-
or
He's
just
talking about
Courtroom?
yours.
I'm talking about Hunter Town, I'm talking about Hunter Townhome properties so there has not been any city inspectors to inspect Hunter Townhome since August of 2022?
No, the city inspector has been out, but it just depends on which unit the city inspector decided to inspect.
Can you tell me how you know when and where the city inspector is to be if you are in the back office doing accounts receivable?
I'm one who has to email him the completed forms. So they
So
hand
you
it to
do
me
more.
to email.
Okay, so you do more than just accounts receivable.
I said I do accounts receivable, accounts payables, office supplies, and then I asked you if there was something specific you wanted to know.
Okay, and so you are the one that submits forms to city inspectors or state inspectors, you submit forms?
I can submit an email, yes.
You can submit an email. Can
Yes.
you submit an email in regards to any topic?
Yes.
Okay. So it sounds like your job is more than just accounts receivable.
Is that a question?
I'm sorry, I was thinking out loud. Your job is more than accounts receivable, correct?
As I have already stated.
Yes, okay. I'm sorry, did you answer if the lease was deemed valid for me? For the lease that we are currently on?
You're
Have
in a
you deemed
lease.
it, have you deemed it valid?
Are you saying the lease for you to live there or the city
The lease,
certificate?
the lease that we have on file right now, do you deem it valid?
I believe it is valid,
You
yes.
believe it is valid?
Yes.
Even though I do not reside in 4730, you deem that this contract, this lease is valid?
But I don't know what copy you're looking at. Can you show me what you're looking at that you have?
I have the original copy of the lease, the one and only copy of the lease. And I just want to verify that you deem this lease, this contract valid.
Okay, well, let me ask a clarifying question. Have you seen her lease before?
I have submitted it to, the evictions, but I haven't sat here and gone through her lease.
Okay, and so are you in a position to deem her lease valid or invalid?
I'm not sure I am,
Okay,
but I can look at it and decide, but
okay.
I'm not the one who signs them, so.
No, but because you are part of accounts receivable, you have to verify checks and other things of
I
such.
enter the payments here.
You enter payments and you enter payments to make sure that they're to the right one. Okay. Give you one that was submitted.
You show her, is this part of the,
I am going to show.
the one that
her
was
the
with the complaint? Is that the one you're looking at?
Yeah, with the
Okay.
lease, yeah, the lease that was attached to one of the complaints. This is what I'm going to show. Thank you. All right, where's that memo? Do you have your copy of the memo exhibit? Oh, it's right.
Well,
here.
are you gonna address it? You gotta show her the lease. to
Yeah,
see
I'm
if
gonna
that's
address the
valid.
lease.
Okay.
Yeah, I just needed to pull it out. I'm sorry, I was thinking out loud, Your Honor. Can you verify the address?
This says 4730 Duvernay. And so, but you have keys to 4732?
So do you deem this lease valid?
Your Honor, I'm going to object to the extent that it calls for a legal conclusion.
I agree that this does cause for a legal conclusion as to whether or not this lease is valid.
Do you deem this lease valid?
No, so I'm sustaining his objection. She doesn't have to answer that.
Oh, okay.
The court will make a determination as to whether or not that's valid.
Okay. With her being in accounts receivable because she deals with money and she has to enter in check amounts for each unit, I just want to verify a unit number as such.
May I answer that question?
No, you can't answer the question.
Oh,
Okay. I think at this moment, Your Honor, I have no further questions.
Okay. I just have a quick question. I'm looking at the lease since we brought it up. It says unit type CY 3 25TR, what does that mean?
It's probably just the computer code since it comes, it types on through the computer. It's a designation. I'm gonna assume if it's of a townhouse, but I literally don't look at those codes for these.
Okay, do you know that if there's any difference between 4730 and 4732 off the top of your head?
I
You
know they are both townhouses. That's all I know.
Okay, you don't know any other details? Okay, redirect.
To the best of your knowledge, Ms. Pitts, did Ms. Milton ever indicate to a representative of Hunter Townhomes that she uses her furnace for heat in the summer?
No.
I know you testified about the work order on September 13th relating to the blower that was prepared 2 days later. To the best of your knowledge, was there ever another work order submitted relating specifically to the blower?
I believe not to the blower. I'm thinking motherboard. I'm not sure if those terms are interchangeable, so I apologize. I'm
And
not an ASAP.
another term that seems to be being used interchangeably is memo.
Right.
The memos that are related to Exhibit 4 are internal notes, correct?
Correct.
And one of the, there's no evidence as right now as far as the additional documents that you were questioned about, but I believe at least one of them, and I think two, were dated after March 20th. Those would not be reflected on a document dated March 20th, correct?
Correct.
A group letter sent to all tenants, is that considered by Hunter Townhomes to be a memo?
No. Not necessarily. Can I say that depends on the situation?
All right. And a letter specifically addressed to a tenant, is that considered a memo?
No.
But there could be a memo on the memo board relating to the fact that a letter was sent to the tenant, correct?
There can be.
On Exhibit 4, it talks about on March 20th, a letter that was sent to Ms. Milton that was referenced by Ms. Milton in cross-examination. Is that was noted on the memo board? Was it a memo to Ms. Milton?
From what I remember of that, it was addressed to her. And I believe it was about pet waste, but I just glanced at it.
So would that be a memo or a letter? And maybe we're splitting hairs.
Oh, we are splitting it. Well, it would be a notice. It actually wouldn't be a letter or a memo. It's a notice that went on her door.
And then it's noted on the memo board that it went to her.
Correct.
Okay. Not necessarily a memo to her, but it's noted on the memo
Correct.
board.
Yes.
All right.
And we do make a memo, if I can elaborate, so that if someone does call, we know what actually went to their place.
And you noted that the mass letters are not automatically uploaded to each
They are
individual.
not. They are.
With respect to the inspection by the city, do you know why the city inspected in 2022?
It was time to renew our certificate.
And were there any delays in the inspection?
Yes. COVID actually created a lot of delays, and the city gave us a lot of latitude to get that corrected.
Remember the name of the inspector?
Nathan Odom?
Was he the individual that you sent the paperwork to in June of 23?
Yes.
Your Honor, I don't have any further questions of Ms. Pitts.
May Ms. Pitts be excused from the stand? Maybe excuse me. You can call your next witness.
Your Honor, Plaintiff rests at this time. We do have potential rebuttal witnesses if necessary.
Yeah, you can call your first witness. If you're gonna give testimony, I'll just swear you in if you're gonna be your first witness.
I don't have any witnesses. So I guess
You're gonna
I'm-
testify though.
Yeah.
You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under a penalty of perjury.
I do.
Thank you. You can have a seat and you can give your testimony.
When I signed my lease to move into the home, I had no intention on moving out of the home. I intended that all lease requirements and everything that I intended for Huntertown to meet their obligation, along for me to meet my obligation. I furthermore asked for changes to be made. Huntertown Home was unable to make those changes.
Can I first just ask a question? Because why, can we explain how you signed a lease for 4730 and got a key for 4732?
I am unaware. Upon signing the lease, I was notified via email that the unit was being changed. When I asked for the leasing agent that sent me the email to send me an updated lease so that we can sign it, she told me there was no need.
Okay, so you never actually went and toured or viewed 4730? And selected that specific unit?
No, it was assigned to me upon.
Okay.
Yeah, it was just assigned to me. I was just looking for a
So
townhome.
you get a townhome, and I guess all their towns are pretty much the same.
They have townhomes and apartments, yes.
Okay, so you select the townhome, they assign you a unit, correct? Okay, you can proceed.
Upon being assigned a unit, upon move-in date, I was unaware that we would not be meeting at the unit. So upon signing the lease, there were 4 stations with about 200 people, and we all had to go to each station. One station was to give your money, one station was to give your account information. The other station was to get your key. The last station was to receive a snack. Upon getting the key, the envelope that I got the key for and the folder that I got a key for is for 4732. These are the only things that I received. Something for internet, how to set up internet. I see something about renewing a lease. I see what I can and cannot have, and I see fitness. I was not given any information on how to make a service request. That was upon moving in. Upon moving in, once I got the key and got to the unit, I had help. Stuff was already out. Upon getting into the unit, I took pictures. I had a couple of witnesses. They took pictures and went through the unit. I was leaving a situation that was not deemed reasonable at the moment. Therefore, my belongings were moved into 4732. After contacting them multiple times within that first week.
Contacting
Huntertown.
Oh, Huntertown, sorry.
I contacted Huntertown August 1st at 1:59. It was a 3-minute call. I contacted August 3rd at 11:19. It was a 2-minute call and a message. I also called them on August 3rd at 11:21. I called August 5th of 2022 at 2:53. I called August 6th at 9:20 and at 9:22. I called, my last call for August was done August 15th at 9:41, where I had a 4-minute call, and I was supposed to come in and see corporate after work at 5:15. And when I got there, there was no one there.
Okay, what are those calls were in regards to what?
The maintenance, the issues, the following repairs needed being done on move-in.
Okay, and they asked you to come in on August 15th?
When I spoke with someone in the office, and I informed that I would come in on August 15th, and when I got there, the office was closed.
What time did you get there?
I got there at 5:03. I told them I would be there at 5:15.
Okay, You can continue.
I contacted Roxanne in September 15th. She informed me she was new. She gave me her personal email for me to get things done. This was on September 15th. Due to no response, I sent another letter on October 3rd, 2022 to leasing at Hunter Lansing, asking for the correct position for being requested by Andrew on the same day. October 4th, I responded with reference from prior emails that were sent to Roxanne and Julie. I'm unaware if Julie is still there, but it has been known that Roxanne is no longer there.
Okay, what were the calls that you made between August, September, October for issues? What were the issues?
I have a list. The entire home was dirty from the stains and the spills on the wall, smoke residue and food. Washer and dryer not
Can you
available.
just slow down? Start all over and slow down.
Oh, sorry. The entire townhome was dirty from stains and spills on the walls, smoke residue and food. Washer and dryer not available for use. Patio screen does not slide. No turn on control on the blinds. Multiple blinds have fallen. In the dining room, there were water spots on the ceiling directly underneath one of the bathrooms upstairs. In the kitchen, there were burnt spots, uneven cooktops, which made it unsafe for me to be able to cook with kids in the home. Unattached baseboard, possible mold underneath the kitchen sink, occasional leaking underneath the kitchen sink. Ruined carpet on the stairs, light fixture was broken. The sinks lifted up out of the from the vanity, where you could lift up the whole sink out of the vanity in two of the bathrooms. The toilet was loose, the toilet seat was broken, the towel bar was broken. In one of the bedrooms, patches along the wall were missing. In another room, the doorknob didn't work. There were dents. On the wall, there had been a broken sliding glass mirror. The closet is a mirror, it had been broken. And that was one of the children's rooms. A sink stopper didn't work, dryer vent. One of my kids has health issues with breathing, so I deemed this hazardous. A lot of smoke smell. The peeling on the walls, these were all the maintenance requests put in. I was unaware of the furnace not working until September when I went to use it. Even though it is the summertime, I do, however, have some health things going on, so I get colder sooner than some people. As of right now, I am cold in the room, but that is just a personal thing. So I do deem the washer and dryer to be included in the rent, and I was unable to use that. With the light fixtures being broken, I have 4 kids ranging from the ages of 6 to 13. That causes hazard. In September, when I notified them of the furnace going out, it took them, I don't have, I have the date somewhere. When it was fixed, I do not recollect that it goes along with their date though, because I was out of the home. After just making multiple attempts to get things fixed, I essentially have been staying in hotels and staying with other family members. That was not my intention. I went into this with intention of having a home. Yet Hunter Townhome did not hold up their end of their obligation. I have not been able to use the furnace. I did get a memo that they tried to turn on the furnace. I have been trying to work the furnace for a week and it was not working. Therefore, I turned the thermostat to off. Upon maintenance coming in to check on the furnace, they did not check the furnace. They just deemed the thermostat to be off, and which I had turned it off because it had not been working. So therefore, I didn't want the bill to be accumulating. At this point, I would just like to be able to not have anything on my public record and be refunded for the initial move-in amount. And being respectable time to get the remaining belongings out of the unit.
When did you get to the place where you moved out and you could no longer stay there? And why did you leave the property? Says you've been, your complaint says you've been living in hotels since November 2022.
So I have been in and out of hotels. At this current moment, I am with an ex.
Yeah, but I wanted to, what put you in a position to go to a hotel? What was going on at the property?
There was no, the heat wasn't
The
working.
furnace was out?
The furnace was out.
Okay,
That's what deemed me to leave.
okay.
As of
You said there was flooding?
April 1st, there was, when we had a lot of rain, the basement flooded, the walls, the water went in the basement. So pretty much all along I guess the ceiling of the walls, I would say in the basement, water was coming down. The floor was completely soaked. I had damaged property. I don't know if it's called a drain. There's like a black thing that is on the outside of the townhome. I don't know exactly where that's supposed to go, but I still have flooding. The ceiling in the dryer room, the ceiling in the back room of the basement had fell in. They had to come and clean that up. After that, there was more flooding. They had to replace a pipe in the basement as well.
And you allege that there's no valid rental certificate?
Correct.
What causes you to believe that?
Because the unit is incorrect. And if any contract is to be upheld, I would believe that every letter, every number will be deemed correct.
Okay, so when you're talking about rental certificate, you're actually talking about your lease?
Correct.
Okay, because a rental certificate is different under the law. You do recognize that?
No, I did not.
Okay, so the city of Lansing issues a rental certificate to allow them to rent.
Okay.
You're not attacking that. You're saying
No.
that your lease is invalid. Gotcha.
That's
Okay.
correct, Your Honor. I was unaware of that word difference.
Okay. Anything else you want to share at this time about the warranties of habitability and fitness?
The possibility of black mold growing in the basement.
Okay, and when did you notify them of that?
It was a phone call because I don't know. At this time, I do not have the exact date. I do know that when I notified them of the rain, I believe it was within that first week of April 2023 that I notified them, because that's when I started to see it.
Okay. Okay, and when was, if you know, when was your furnace replaced or repaired? Your complaint says November 2022 to present, the furnace is completely disabled.
The furnace hasn't been repaired.
So to your knowledge, it's still
Yes, I go
in disrepair.
periodically. Correct, I'm sorry, Your Honor. I do
Okay.
go and periodically check on the unit, take a picture of the thermostat to see if the temp has changed, and I do turn it on and off.
Okay, and when's the last time you've done that?
That was yesterday.
Okay, and you say you took pictures and video of that,
Yesterday, I did not take the pictures.
but you
of.
have done that in the past?
Yes, I have done that in the past, and I do have pictures of that.
And when are your pictures from?
It's okay, I pull out my phone the other day.
Sure.
November 19th, the furnace November 19th, 2022 at 9:50 a.m. It was 51 degrees and the heat was on and the auto was on.
Okay, did you go since then to check to see if it had been repaired or addressed?
I have. I have a March 10th at 4:25.
March 10th, you went and checked?
I have a March 10th. I have hard copies of the photos. I unintentionally left the folder with the pictures that were printed off, so all I have is.
But you have those on your phone, though?
Yeah, but
And you went to go check, and what happened?
There was no heat that came on.
Do you know what the temperature was in the house?
On March 10th at 4:25, it was 52 degrees.
Okay, any additional testimony at this time?
On September 13th, 2022 at 6:21 a.m., the temp was at 67 degrees in the house.
And you put in a work order for the furnace, it looks like back in September, correct?
Correct.
And did you, I know that there was a follow-up that looks like November. Let me double check. November 8th, there was a follow-up, heat is not working.
I do have a date for December 26th of 2022 at 3:17 p.m. It's 43 degrees in the townhome.
Okay, you said what date was that?
This last date, December 26th, 2022.
You put in a work order that day, or you contacted?
No, I'm sorry.
Oh, okay.
I'm sorry. I was
Okay.
looking at the temperature. I'm
You're
sorry.
saying that the furnace was still having issues then?
Yes, ma'am.
And what was the temperature?
43 degrees the day after Christmas.
Okay, I do see the furnace addressed in December 14th phone call. Let's see. I don't see any more work orders from December until April 3rd of 2023. Are you disputing that there were any work orders between that time frame that they are not reflecting?
At this current moment, I do not have a hard copy of any work orders put in during that time because I was in and out of the home. I wasn't living there.
Okay. Did you make phone calls to them between that time?
I believe there was a phone call that I had placed to see if anything had been updated. One moment. Maybe no better. Okay, my last communication with Hunter Town was December 6th, 2022. I was checking the status of the furnace completion. I was informed by Mac, the HVAC contractor, that no one had been back on site and there was a list of properties in need of their furnace being
Your Honor, I'm going
replaced.
to object to what a third-party contractor told her. That would be hearsay.
This
Not
was,
not a representative of Hunter Town Hall.
I'm sorry, Mac, let me clarify. Mac from Hunter Townhome Properties informed me the HVAC contractor had not been on site and there was a list of properties in need of their furnace being replaced.
What day was this?
This was December 6th.
Okay, so you made a call December 6th?
Correct.
Okay.
It was noted my online account was restricted due to being in the eviction stage for Hunter Townhome Properties. When I asked if if anything, if I could see the ledger, the leasing agent informed me that nothing could be paid or done. When inquiring in regards to the living room outlets going out, Max stated Ray from maintenance came in on November 28th, 2022 and fixed the living room outlets, yet there was no note left at the home stating such was done. On November 8th, I spoke with Drea and submitted a verbal maintenance request, but the last that I have, oh, actually, no, I got this month, I went and got a copy of my maintenance slips. I went into the office.
You went into the office and got a copy of your maintenance slips?
My maintenance work orders, I'm sorry.
Okay, and are there any extras other than what they submitted as exhibits?
Give me one moment, Your Honor. Just a moment. There's 5 work orders that were submitted. I was given an email to put in work orders on August 5th. It was at service@apartments247.com for Town Square Hunter. And I received a confirmation to my Yahoo email with the contact from, the confirmation email came from Town Square Homes. No work has been done, and I do not have those slips sit in. And that was August 5th, and it was placed at service@apartments247.com.
Okay. You put a portion of your rent in escrow. What month was that for?
September.
Only September?
October.
September and October in escrow. And why did you not escrow the remaining months?
Because they failed. And once I realized that the lease was incorrect and they failed to complete any of the work orders.
Okay, and what legal basis are you relying on as to you not needing to escrow because they failed to?
I believe that the lease was incorrect and I asked multiple times for it to be changed. And after the furnace not being fixed, it was deemed to me as if the property was gonna go unfixed.
Okay, and then you remove yourself from the property in November, meaning you took your children to a hotel?
Correct.
Okay, and did you go back to return to live or reside in the property?
No, we were in and out getting clothes.
Okay, but why did you not move your stuff out of the property in an effort to mitigate damages?
It was the winter time and I knew that a legal proceeding was going to be coming. Therefore, since they already filed, I did not want to pay out. I did not want to have to get an attorney on my own because I deemed that I did everything right on my end. And so that this was something for the defendant to fix.
Okay, but my question is, why didn't you, if you're not living in the property and it was in your position unsafe and unfit for you and your children, why didn't you tender the keys, pin in, and move into another location? Is it because you were waiting for the eviction to be finalized? Is that what you're saying?
I wasn't waiting. It wasn't, the winter time was not a good time for my kids and I to move.
Okay, but you weren't living in the house. Is that a no?
That's correct. No, ma'am, I was not living in the house, just the property. My belongings were in the home.
Okay, cross-examine.
Thank you, Your Honor. Was spring a good time to move?
Summer's a good time to move.
Okay, and temperature's been very, very nice going back to the middle of May, but you've made no effort to move, correct? Yes or no question?
Correct.
Right. Now, You stated that when you moved in, you didn't get the procedure for submitting maintenance requests. But August 5th, you just testified about, I think, some type of email address. Is it your testimony that as of August 5th, you had received the procedure for making maintenance requests?
It was not the correct procedure that I received because upon submitting
No,
those 5 maintenance
it's
requests.
a yes or
No,
I mean, you've
it
answered
was,
the
it was
question.
incorrect, no.
Okay. And as of August 31st, would you agree that you had the procedure because you submitted a maintenance request?
No, I would not agree.
Okay, how about September 13th?
How was the maintenance submitted?
No, by September 13th, did you have the procedure down?
I am unaware if I had the correct procedure.
Well, it was certainly addressed 2 days later, wasn't it?
Do you see that date?
Yes.
Okay.
Okay. By November 8th, would you agree that you had the procedure down?
If the September 13th was submitted, then if they received any of the remainder ones at that time of the September 13th, then it must be correct that I had the correct proceedings upon initial move-in. I did not, however, have the
All right.
correct proceedings.
December 14th, there's a maintenance request for, among other things, that the furnace needs new filters. If the furnace was inoperable, why would it need filters?
Because the furnace was requested prior to moving in that new furnace be placed in because I have a daughter who has long-term asthma. And it was
But
no.
your testimony is the furnace wasn't working.
It was deemed prior to moving in, it was requested for new filters to be placed on the furnace.
That's not the question. The question is, if the furnace wasn't working, why does it need filters?
It's a hypothetical. Can you rephrase the
Well,
question?
no, I mean, your testimony was that the furnace wasn't working. If the furnace wasn't working, it wouldn't need filters, would it? If the furnace was inoperable.
I'm not an HVAC specialist. I know that as a mother with a daughter who has long-term asthma, it is beneficial for furnaces to have new filters and certain things to be conducted in the venting system with a child that has long-term asthma.
Isn't it true that the furnace was working on December 14th and that's why you needed the filters?
No, that is not true.
You did not put a single work order in after December 14th relating to the furnace. Isn't that true? I'm talking about these written work orders that are part of the exhibits that are before the judge right now.
The last work order submitted is the last work order of 2022 is what you have in December.
All right, and there is nothing from 2023 that references the furnace at all. Is that correct?
There was a verbal.
I'm talking about a written work order that showed up as an exhibit here. The judge asked you if you had any other work orders in your possession, and your answer to that was that you didn't have any written work orders to show the court, correct?
It is a possibility there are verbal work orders that are not transferred to hard copy work orders because, as the witness stated, work orders are able to be received via verbal with a phone call or placed via online.
All right, and you didn't provide any dates or times of those from 2023, correct?
I don't believe I was asked for it. What date or time are you?
Well, what I'm saying is if there's not a work order that's submitted, property wouldn't know about it, would it?
If the work order is submitted, just because we do not have a hard copy does not mean that it was not submitted verbally, because Hunter Townhome takes verbal and written submissions.
But you weren't able to provide the court with a single date in 2023 when you provided verbal notice, correct?
In regards to
The furnace.
the furnace, they do not have at this moment, I cannot answer that. I have to finish looking through to see what is the last hard copy work order, not verbal order.
Well, the last hard copy was April 3rd. We've established that with the exhibit,
Did you
correct?
call at any time in 2023 to report the furnace not working?
Yes, I did.
And if so, what was the date and what was the time? You were very specific as far as dates and times in August of 22.
Let me get to my notes.
While you're going to your notes, I'll follow up with this.
Can I take one question at a time here? We're looking for a date and time and who I spoke with in regards to letting Hunter Townhome know that the furnace was still out for 2023, right?
Yes.
Okay. At this current time, I do not have the note for when I recently talked to the leasing office, but I did talk to them last month.
Did you ever call a repairman or repairwoman to repair the furnace?
No, that was not my obligation.
Well, I'm talking about in terms of mitigating your damages instead of imposing on friends or family or staying in a hotel. You could have simply called a repair person and had them come out and do the work, couldn't you?
No, because I do not own Hunter Townhome properties. It was not mentioned in the invalid lease that I would have to call or outsource or pay out of pocket for any damages done to any of Hunter Townhome Square properties. I do not own them, so no.
Is there anything on any of the work orders from 2023, and I think there was only one, that mentions mold?
The mold was discovered after April 1st of 2023.
And you didn't put a work order in for it, did you?
That very well can be a part of the verbal notes that I am looking for when I spoke to Hunter Townhome. So I cannot admit nor deny that at this current moment.
And your testimony was that the basement flood that was reported April 3rd, they cleaned it up and replaced a pipe. So and that occurred when?
The cleanup, I have no specific date on the cleanup due to being in and out of the home, and there was no maintenance slip left to let me know that anyone was in and out of the home. So I do not have that specific date at the moment.
All right, but it was done.
I
You agree?
cannot agree to that because I cannot agree to that.
Well, you testified that they cleaned it up and repaired a pipe. Now you're saying they didn't?
I cannot agree to the dates of when those things were fixed.
All right, but you didn't do it yourself, correct? Hunter Townhomes did.
I don't own them.
How often did you go back to the townhome after you vacated?
Roughly within once a week.
All right, and your key worked every single time, correct?
Correct. I was never locked out. It was never meant that I was going to be locked out. I never insinuated that I would be locked out. I wanted to make sure that I would not be locked out.
All right, so, Your Honor, at this time, based on this, the testimony, I would move for the dismissal of the defendant's counterclaim for lockout, since she just acknowledged she was never locked out.
That's noted. You can continue.
All right. What are the belongings that are still left in the town?
An overview.
Briefly, you don't have to go into. every single thing.
No, briefly, couch, bookshelves, books, kitchen appliances.
How long did it take to move those items in?
Yeah, that's where this question is going.
Well, it goes back to mitigation of damage.
Objection relevance is what she's asking.
It goes back to mitigation of damages. If it took an hour and a half or 2 hours to move those items in, presumably it would take an hour and a half or 2 hours to move them out at any point in time.
I'm not following why that's relevant though.
Back to mitigation of damages. I mean, the court inquired as to why she didn't move. If there's hardly
She said
anything there.
it wasn't a good time for her to move, so she's probably got a ton of stuff in there. She's still occupying the property.
All right. And you would agree that you're still occupying the property?
I would agree that I have belongings in the property and that I do have a key. I do, however, not sleep in the property.
So she still has possession of the property.
Thank you. All right, I don't have anything further than Your Honor.
Thank you. Any further testimony from you?
Not at the moment because I like certain evidence.
Well, testimony is evidence. I didn't know.
Okay, and I believe I've stated everything outside of not having the specific dates. However, I did speak with someone when I went in the office to receive the request, the inspection, the work order request. I did speak with someone. And that was of June.
Okay, I do have a quick question. I'm looking at the work order from August 31st, 2022. Says call date was August 31st. A little concerning just because I do see there in this memo, at least there should have been a work order from August 15th because they put in the memo that you called about some issues, but I don't see a work order. So nonetheless, August 31st is what I see, a call date, work order submitted. They noted that they visited 3 times and that they were not going back because you asked them to leave. Did you ever ask them to leave when they came to your property?
No, ma'am.
Okay. Has there ever been a time where they came to your property and it maybe wasn't a good time for you and you asked them to come back?
No, ma'am. During the time from August up until November, I was working with Spiro. I had to have headphones on. And I was, I'm sorry, it was a
Oh, so you
call
worked from
center.
home?
I worked from home. So if they came to the door, it is possible that I did not hear the door because I worked for a Spiro radiology call center at the time.
Okay, I don't see where it says no answer. It says that they were asked to leave. So that was the direct question that I had.
Okay, sorry, no,
Okay.
I never told no one directly to leave. My apologies.
Okay, and are you alleging that there was times where they entered your property when you weren't there?
Correct.
Okay, and was that because of a work order?
When the flooding just happened with the pipe that burst, I went to check on the property, noticed that they had put some industrial fans in the basement. I was not aware of that until I seen the fans. And then I turned the fans off due to not living there and the bill running high. I was informed that I had to leave them on. When I asked Hunter Townhome and email if they would compensate the bill for the timing that the fans were running, I received no reply back. They kept the fans off. As of yesterday, when I went to check to see if the fans were still there and if the furnace was working, the fans were gone. And I have I don't have any maintenance slip that they entered into the home or they left the home. I don't have any hard copy of that.
Okay, so there was some flooding in April.
And then a pipe burst.
You said a pipe burst when?
In the basement.
When?
I believe that was end of April, early May. I left a folder with more dates, my apologies.
Do you know what caused the pipe burst, or are you aware?
I do not know, but I do have pictures of the pipe. It was a black pipe, a main pipe, and it was carotid. There was going.
So there was a pipe burst and then they entered to address the pipe bursting. Is that a yes?
Yes, so I was able to submit a verbal work request for the pipe bursting. That's how they entered into the home.
Okay, so you discovered that a pipe had burst. Okay, is that a yes?
Yes,
Okay, and then you made a report, and it's common, people do it all the time.
I'm sorry.
No,
Yes,
that's common. And you submitted a report, a work order request, correct?
verbally.
Okay, and then they came in and the next time you went in, you noticed that there were some fans in there.
I heard them, correct.
Okay,
I have been in and out of the home since April to pack. I have been back.
okay. And the pipe burst was in the basement,
Correct.
and you store stuff in the basement?
On the April 1st flooding, I immediately disregarded what was lost, and then I got a U-Haul and took the things out of the basement to a storage.
You discarded what was lost?
Yes.
Okay, what was in the basement?
I also braid hair, so I had hair salon equipment. I had some clothing, I had some memorabilia.
But you've not made a counterclaim for that, correct?
No, ma'am.
Okay. Let's see. Anything else?
No, ma'am. I'm sorry.
No problem. Recall any other witnesses today, ma'am?
No, ma'am. I'm
There's
sorry.
no
It's
other
my
evidence? Okay. You can proceed to argument. Your closing argument.
Your Honor, I guess I'll address the fans first. The purpose of those big industrial fans is to dry the water quicker and prevent mold.
Well, you
So,
can't.
I mean,
give me that.
it's a matter of common
can't-
sense.
Yeah, and you can't testify as to what the
Right.
purpose was.
Right, but I've been through it.
Right.
Court has concluded that the tenant occupied the residence. The court has duly noted that the tenant paid nothing into escrow after October of 2022. I would dispute whether the tenant paid anything into escrow, as she has no evidence of that or didn't present any evidence of that. And as I understand the Michigan Landlord Tenant Act, when you set up the escrow account, the landlord is to be notified of the location and the account number so that the landlord can confirm with the financial institution that the account actually exists. So I don't think that the tenant properly complied with the Michigan Landlord Tenant Act. With respect to whether or not the premises was habitable, we have no communications from December 14th of 2022 until now relating to the furnace. And December 14th communication was, I need furnace filters. And I would suggest to the court that the logical inference of asking for furnace filters is that the furnace is operational, but for some reason a filter is needed. There is no indication independently that the furnace was not working as of January, February, March, April, May, or June, simply because no repair person was requested by the tenant to come out and look at it. No repair person was requested from my client because there was no repair request. And if my client doesn't have a repair request, they simply aren't going to know one way or the other without illegally entering the premises, whether the furnace is operating or not. In addition, I'd respectfully submit that at minimum, as of April or May of this year, you're not in a situation where you needed a furnace anyway. And that would also apply to August of last year, September of last year, and because it was a warm, the court can take judicial notice that it was warm into October, I would say October of this year, of last year as well.
I can't take judicial notice of that. I can't remember what the temperatures were in October.
All
It
right,
could have
well,
snowed in October. I can't remember.
It's argument, it's not evidence, Your Honor.
Okay, I don't know. But I do have a concern though, about the statement about the unlawful entry. If she's made a complaint or a work order for the furnace, and why wouldn't they be able to enter?
If she made a complaint or if she made a work order, if she submitted it, absolutely they could enter.
Oh.
What I'm saying is because there wasn't a work order, they wouldn't know. So unless they were going to come in on their own and check for it, which they're not supposed to do, they would have no knowledge. They needed the prompting by way of a work order. And after December 14th of 22, there was none. That's the point that I was trying to make.
Okay.
Now, in terms of habitability, there are a number of appellate decisions with respect to whether a property is fit for its intended purpose. And I'll just give you one example. A bed bug infestation was held to be inadequate in the case of Florizio versus Forbes. And that was an unpublished opinion at 2020 Mishap Lexus 2145. But then they cite other published opinions, including but not limited to the state of True Blood versus P&G Apartments, found at 327 Mishap 275, 933 Northwest 2nd 732. In the Florizio case, the court found that the plaintiffs failed to explain, the plaintiffs who were suing the landlord, failed to explain how the presence of bed bugs made the property unfit for its intended purpose, and therefore they had abandoned their claim under MCL 554.139, sub 1, sub A. The court has in its possession various exhibits, none from the defendant. The exhibits show, A, that the parties, the amount owed, as is shown on the ledger, tenant did not dispute any specific charge. B, work orders and how they were addressed. And tenant has not provided any additional written work orders above and beyond what was reflected by our client. And finally, in Exhibit 4, the memo section, where it is noted that the tenant specifically stated that she wasn't going to pay rent until all these repairs were made. And then I think the question dovetails back to, did the tenant comply with the Landlord-Tenant Act properly? With respect to the counterclaim, the tenant has testified that she was not locked out. Therefore, her claim for lockout must fall or fail. With respect to rental certification, I think the tenant, under some questioning from the court, acknowledged that she was not suggesting that the property was not certified by the city. Ms. Pitts testified at length about her involvement and interaction with the city as far as that rent certificate. The court certainly has the discretion to modify the amount of rent in terms of what would be due and owing at this time. Any amount, Your Honor, we would submit would be appropriate for a possession judgment to be due within 10 days. Actually, it would be a little longer because of the holiday weekend. And I don't know if the court is open July 3rd. It might extend over to July 5th. And that would be a 10-day or the proper statutory time period for the tenant to either pay or move. And certainly we are now in the heart of the summer, in the thick of the summer, and there would be no reason that the tenant could not vacate in compliance with the judgment. Thank you.
You can make your closing argument.
I do not agree with the ledger that was provided due to the lack of thereof on Hunter Townhomes, and to uphold the correction of a lease to be in good standings for a contract. In the state of Michigan, the weather is undeterminable. Therefore, the use of a furnace should be valid at all times. There is some miscommunication from the front office and the back office of Hunter Townhomes, and it is questionable to how accounts receivable is able to conduct business without being in contact with the front office. The specificity of memos / letters, the word being used interchangeably is unclear for how the memo or letter is sent out and why it is not logged. I have pictures with dates of things needed to be corrected. Unfortunately, at this moment, they are in a folder that is not here with me. I do believe that no monies are to be owed to a lack of contract.
Okay. We're gonna take a break since we've been here for a while. For lunch, we'll adjourn until 1:00. Then time to review the exhibits. And I'll give my ruling at that time.
At one.
Thank you, Your Honor.
Julia, it's 12:20. Give me till 1:15.
Okay.